thinking or self-respecting South African ought to be getting funding from. So we need access to their private funders, to information relating to private funding, so that a particular right that we have can either be exercised by us or protected.
Yes.
It's not jeopardized by their private funding.
Yes.
So that's what I'm looking for.
Yes. Chief Justice.
So that we don't confine it to voter when in fact other people may well want access to that information.
Yes.
The media, for instance, may want access to that information. And then you're going to say, no, you people just want to write a story. You don't want to vote, so I'm not going to give you that information because you don't fall within the language of Section 32.
Chief Justice, if I can answer it this way, there's a practical answer and then there's the constitutional answer. Just to explain.
Is the constitutional answer not practical as well?
They're both practical and constitutional. But Chief Justice, the point is this. Your concern doesn't arise practically, even if it's just the voter that was entitled to that information. The concern wouldn't arise because the voter, by necessarily exercising the right and getting the information, that information would be publicly available to the media, to political parties, and everybody else. That's the practical outcome.
No, but how? How does my mother now, who wants that information, suddenly make it available to everybody?
Because it's going to be recorded. That's the relief that we're seeking, that there's a recordal of the donations in a systematic way. And we'll speak to that in a second.
Maybe you should explain to me what that recordal in a systematic way is.
I shall do. But
if you could do it before you go to remedy, because I've got other questions that are not necessarily related or intimately related to remedy.
But if I may complete that point, because it's an important one that the Chief Justice raises, that it's also the case that reading any information, any person, it's absolutely constitutionally permissible and indeed foreseeable that a political party, in the context that the Chief Justice has described, may wish to say, I want access to that information because I'm worried that that big political party is getting donations from corrupt individuals, lobbying by big business or corrupt individuals. So there would be certainly a claim on behalf of the political party who would say, I want that information.
On the basis of which law?
On the
or
basis,
which section?
On the basis of Glenister. And
No. How?
Because Section 32(1)(b) says that everyone is entitled to access to any information related to the exercise or protection of any rights.
So which right is being exercised or protected?
This court, Chief Justice in Glenister, has said that corruption as a scourge undermines all the rights.
I agree, but now how are you exercising or protecting in relation to that?
Well, it's a two-step argument. If corruption as a fact between a big corporation and a particular political party is detected by that information being disclosed, if that is what's going to ultimately avoid the corruption, and I get information about that, then what have I done? I've ensured that corruption has not happened. But the corruption not happening, Chief Justice, means that the impact on rights throughout the Bill of Rights has then been ameliorated.
You and I are lawyers. Which right are you protecting? That's all.
The rights in the Bill of Rights.
Which one?
Chief Justice, this court, I can't do better than what this court said in Glenister. This court in Glenister said that the corruption impacts on all the rights in the Bill of Rights because, by definition, it undermines the very constitutional project. So when it says in Section 32(1)(b), I'm entitled to access to information for the exercise or protection of rights, it would be, at least on the debate that the Chief Justice and I have been having, permissible for the political party that wants that information to say, I want to get the information because I want to ensure the protection of rights.
You see, Mr. You're too general. Let me give you an example. If, for instance, accountability was a right, if transparency was a right, I would understand it if a business person rocks in and said, no. Or a political party comes and or any other person who doesn't want to vote for that party even, in fact, he wants to destroy that party, comes and say, I want to protect my right to transparency or accountability, if they were rights. So I want information. So people can't just steer clear of accountability and transparency.
Yes.
Then you would be talking to me. There's a particular right to be protected. But am I making sense to you?
Yes, Chief Justice. But that particular right that you're protecting is already inherent in the rights in Section 32(1)(b) to information. As we said, Section 32(1)(b) protects the right of access to information, read with the idea of openness and transparency, which is the constitutional principle. So there you are saying, I've got a right of access to information.
Yes.
It is an informational right, but it is, as we know, referential in relation to other rights.
Yeah. I think I suggest you go and read it again and interpret this in relation to my question. Let me move on to another question. Let's look at Section 19(3)(b). It reads, are you there, Mr.
Yes.
Du Plessis? Every adult citizen has a right to stand for public office and, if elected, to hold office. You make reference to independent candidates in your papers. That's why, and Mr. Masuku also touches on that. Now, and I want to tie it up to this recordal of information, disclosure of information. This seems to suggest that any adult citizen has a constitutional right to stand as a candidate, to become a member of the National Assembly, to become a member of the provincial legislature, because the Constitution says so. So any 500 or 400 people can decide, people, we are not going to pay this 600,000 that the IEC wants us to pay. We don't have money. But we are citizens. In fact, we don't like any of these political parties. There are too many of them. Somebody was saying there are 500. I thought there were 125 there, but apparently the number has increased. We don't want any political party here. There are too many rules, deployment and redeployment. I want to stand for office as a member of the National Assembly, member of the provincial legislature. And if they win, they are entitled to report themselves now on the appointed day to be sworn into or affirmed into office. And even as once sworn into office as members of the National Assembly to say, I'm making myself available for the position of president now. No political party. That's what the section seems to be saying. Whatever logistical challenges the IEC has, whatever habit it is in of reflecting only the names of political parties, somebody can say, but the Constitution doesn't say that. You can't override the Constitution through some practice, some code, or some legislation. Let's work on that assumption, particularly because you're saying independent candidates. You didn't say at the municipal level. I assume it applies across the board. How then do you deal with their funding? How are they to deal with the funding issue?
Well, we have
They
said
disclose in the same way as
Same way.
political parties?
same way, because they would be standing as a conduit for the constitutional system. They would be effectively alongside political parties, championing for political power, and if elected, then embracing that political power and exercising it. So that's why we didn't draw any distinction between them.
And an association, can an association, is it supposed to submit information as an association or as individuals?
An association in what sense, Chief Justice?
We come together, we are Sanko or something, we are not a political party, or we are even COSATU. You say there's nothing in the Constitution that says as COSATU, we can't field our members. We don't want to register as a political party. We don't want to pay anything. We shouldn't be paying for our constitutional right here. We're fielding our people. Now, the funding they receive from wherever, do they register or have it recorded on behalf of COSATU or the individual members that stands as candidates?
We've not been that ambitious, Chief Justice. We've limited our case to the political parties and to the independent candidates. That's a fight for another day, whether there's an association that might fall within that remit. Our challenge is to, at this point in time, the right to vote in respect of political parties and independent candidates.
Oh, so those you are not,
We,
okay.
we are not that ambitious in this application, Chief Justice.
Okay.
But that's, you're referring now to registered political parties.
Yes.
So a party that receives funding that assists another party, assuming Party A and Party B are in alliance and Party B contests the election, but Party A receives the money. The relief you seek does not reach Party A, at least in these proceedings.
No, not in these proceedings. We are limiting ourselves to those that are registered. So,
And
sorry, Chief
what did you say about information that is just that has not been recorded on any paper? What are you saying about it?
We're saying that the right, Chief Justice, in Section 32(1)(b is not limited to that which has been recorded. It
Yes.
simply speaks about any information that is held by another person.
For the purpose of your case, are you saying it's enough to record it in your mind, or should you
Absolutely.
go beyond that?
Absolutely, Chief Justice. It's like us, it's to give the example of I hold a thought.
Yes.
I hold it in my-
Which you may forget,
possibly, but
even conveniently.
exactly. But if I hold a thought, but I know that I've got a duty because I hold that thought because it was a donation given to me by somebody to use their stadium in exchange for something, I must record it.
Yes.
So that I don't conveniently forget it, and so that I don't have the advantage of not having to record it at all.
Now, I just remembered something. For the purpose of doing justice to your argument as it relates to independent candidates, and knowing that really we've never had independent candidates for national and provincial elections, how are we to handle that? Are we to say something about it? Are we to assume? What are we to do?
Chief Justice, I think it's enough to do the objective constitutional
Okay.
inquiry.
Okay.
And then whatever happens later
Okay.
would be caught
Okay.
by the judgment.
Okay.
If I might then move, subject to any further questions, Chief Justice, to remedy.
Required. What does it mean? What do you mean required? Is it always automatically required, or is there more that you need to say to satisfy the requirement?
Chief Justice, I'm going to deal with that now in remedy.
Okay.
So, Chief Justice and Justices, what we then say on remedy is that Pyre is meant to give full effect to the Section 32 right. This court in the majority in my vote count said that it's through Section 32 and Pyre that one must understand that Pyre is meant to cover the field. But we know that it doesn't do so for the reasons I've given in relation to private funding information of political parties. And we say that disclosure under Pyre is therefore not a continuous process, affording citizens equal access to the information. We know that because it's on request. It's as the particular requester requests from the particular political party or parties. And so this court, we say very helpfully in the minority judgment of my vote counts at paragraph 96, put its finger on the difficulty with Pyre. It said that the right of access to information is important, but it's not capable of affording the electoral citizenry the information to which they're entitled about the way political parties vying for their votes are funded. Said this court, that is a context with unique demands to which Pyre does not address itself. The right of individuals to apply to receive individual records furnished on request could never keep the electorate as a whole meaningfully informed. For that to be achieved, said this court, records must be made publicly available to all, and this would have to be done, and these are the important words, systematically and regularly, not only upon application. So that it must be systematic and regular, we certainly embrace, but we wish to go further and add 3 reasons for why we contend for a continuous recordal and on a systematic basis.
Well, before you do that, are we to assume that citizens need that information? Why shouldn't it be upon request?
Well,
Why should it not be available to those who require it?
it is required by the citizenry for the reasons we've given.
No. It's an assumption. Some people may require to know. Others don't even care.
Yes, Chief
They
Justice.
just go to the stadium, listen to leaders of political parties. We like him. In fact, he's even our relation, or he comes from our village, he comes from our region. We don't need any information. Why should people who don't need information be bombarded with the information they might not even need? Why should people not say, but we need that information, and then it is for those who need it that it is given?
Well, Chief Justice, because the difficulty is, of course, we don't know why people want information or not. Some people might not want information because they don't know that they're entitled to it. Once they know it's available, they might be very interested in the information. Right now, that's not the situation in the country. Most importantly, though, in this context, there can't be an assumption that some might not want it, so therefore all shouldn't get it.
The Constitution said require.
Yes.
Yes.
Yes. So reasonably required in
And,
this
and you
context.
even have to demonstrate for the exercise of which right.
Yes.
So it can't be imposed on people.
No,
It is those who require it.
Indeed, and so-
it can't be assumed on their behalf that they require it.
No, in this context, this court has already made clear that in the judgments that I...
No, but it's not binding. It's persuasive but not binding. We still have to reflect. Which one are you talking
No,
about?
Chief Justice, in Ramakatse,
Oh, I
in Mail
see.
and Guardian, this
That it
court-
is required
that it is required
by everybody.
for citizens for the exercise of their vote.
Yes, but that is it not citizens who need it?
No,
Why should we assume that 10 million South Africans want to know who's funding who? Why should we?
because
What is it based on?
Because, Chief Justice, this is a right objectively speaking. It's not about whether a particular portion of the citizens in a particular part of the country in that province need it more than others. This is about whether the citizenry as a collective of individuals, all of whom have the right to vote, and this court has stressed have the right to make an informed vote, can have that objectively achieved for them without the information. So it's an objective inquiry. And in this context, it's in the same way that everyone has the right to vote. Very many people might say, but I don't care about these political parties. I never vote anyway. That doesn't mean that they don't have the right to vote. They do.
So how is it to be made accessible to everybody?
In this way.
Either actually or potentially.
Let me explain, Chief Justice. So we say that, first of all, as a matter of rights and duties, it's important to understand the nature of what we are asking for. Because the electorate, we say, is already entitled to the information in its entirety from all political parties. Because Section 32(1)(b) says everyone is entitled to the access to the information necessary for the protection or exercise of their rights. And we've made our arguments for why we say there's a relationship between the citizens who are voting and their electoral rights and that information. And as a correlative duty then, we say on political parties, the political parties are then obliged to fortify and to give an effect to that right, that informed right to vote, by making continuous and systematic disclosure of private funding information. If they did it in a manner which was hopscotch, ad hoc, in response to requests, as the minority judgment says, what you would have is, you would then have a patchwork of disclosed information. You wouldn't get a continuous overview of what information has been disclosed. You'd get the patchwork. So,
I'm sorry, Mr. Duplessis.
Yes,
Just on that, isn't that the incidence of the limitation to that right imposed by Section 32(1)(b) itself, the one that you have just debated with the Chief Justice, the limitation being that you must demonstrate that you require the information for either of the two purposes, exercising a particular right or promoting or protecting another right.
absolutely. So, Justice Chapter, that leads to the point as to why we say it needs to be continuously disclosed in order to meet precisely that outcome. So,
No, but if the right itself has a limitation, before you exercise it, shouldn't you meet the limitation? In other words, if you want information, access to information, is it not your duty as the person who claims access to information to show that the information that you need access to is required for those particular purposes.
And that's precisely the difficulty here, Justice Chapter. The citizenry, it's impossible for the citizenry to know about donations or benefits that come in secretly. That's precisely the difficulty. Because in this context, in particular under Pyre, there's no duty to disclose anything other than which has been recorded. Private donations, secret donations, foreign government donations, donations in kind, you wouldn't get access to. And the citizens would simply not know about those donations, which is why the obligation imposed upon political parties, precisely to give effect to those purposes of an informed citizenry and to detect corruption, has to be an obligation imposed on political parties, because it's only the political parties that know what donations they've received.
You know, Mr. Duplessis, I want to tie it up, and my brother may not be through with you. Let me give you an example. I want something tangible, and I'm not too sure you're giving it to me. Let me give you an example with the media. The media may, if we agree with you, approach a political party and say, we want information on private funding. You say, why? Say, well, I've got a right to exercise here. And the right that I want to exercise is to inform the public. So if you people are corrupt, I want to expose you. That's why I want the information. I want to analyze it and see if you people are receiving money from clean people or people with soiled hands.
Yes.
You see, they require it, and they would be able to, they would have demonstrated that they require the right in order to either exercise or protect a specific right, the right to inform.
Yes.
So my brother is saying, isn't it then the responsibility of the one seeking the information, seeking to access the right, to meet the requirements of B, to say, I require it, what do you mean you require it? I need to exercise or protect this particular right, and this is, and give some information in that regard, to satisfy the one who has to disclose that in fact the requirement is met.
Yes, but Chief Justice, the debate that you're having with me about the media house that wants to seek that information, that's
just an example.
Yes, that's an example. It's a very helpful one with respect. It's a very helpful one because it highlights how the media house wants to exercise a particular right in that context of freedom of expression, for instance, and it wants to do so to inform the public about corruption. So it would be able to show that it's entitled to the information as a media house for purposes of its request. Here,
Brother's question.
yes, well,
Then do you deal with my brother's question? He says the section itself imposes limitations in a way. It says the right must, the information must be required, and not just required anyhow for the exercise or protection of a right or rights.
yes. And so the answer is that we're not coming, of course, on behalf of a media house. We're coming on behalf of My Vote Counts, which says it is in this court on behalf of all citizens, and in particular in respect of the right to vote. That's what they're coming to say. And they say in this case that for the reasons we've already articulated, in relying on this constitutional court's decisions in Ramakatse and Mail and Guardian, that already it has been established that the right to vote requires information in order for it to be an informed vote. And so the exercise of the rights here by the citizenry in this context, in this challenge, is to say that all citizens, not one citizen, all citizens are entitled to that, so that there's an informed citizenry, an informed, as this court repeatedly calls it, electorate. The electorate is a body as a whole, and the citizens as a body as a whole need to be able to access that information. That is why when they come to court as My Vote Counts on behalf of the citizenry, they are saying you can't expect each citizen to make that request on an ad hoc basis. Indeed, it would be impossible for citizens to get access to information clearly and continuously from political parties if they did so, because, as this court said in the minority decision, we're dealing literally with millions of voters and potentially hundreds of parties. And so therefore, going to the objective question, what does this require of the citizenry? It's to show two things. One is that as a body politic, we need to be an informed electorate, and that can't happen unless we have this information. And secondly, as an informed electorate, we need to be able to detect post-election corruption. Can't do that unless there is this information and the obligation on the parties to continuously record the private information that they receive. So the answer to Justice Jafta's question is that for all the reasons we've already given previously about the interrelationship between the right to vote and the right to information, Those are the rights required for the exercise of the protection of these votes.
Before my brother put a question to you, let me just say this. You may wish to reflect on his and my questions so that in reply, you really confront them. Unless you're absolutely satisfied that you have answered us. Yes.
You see, Mr. Du Plessis, my difficulty is this. It seems to me, on the interpretation that your client is advancing, the impact of the limitation itself is reduced on the right. You have a situation which is equivalent to saying there's an obligation on political parties located in section 32(1)(b) for recordal and continuous disclosure, which is quite different. I have a difficulty in getting to that obligation as a corresponding obligation to the right that is imposed or conferred with a limitation. And secondly, for me, it removes the distinction between the right in 1A and 1B. Remember, in 1A, for the information that is held by the state, you are entitled to access to it. You don't need to show anything. But the drafters of the Constitution, in their wisdom, insofar as the right in 1B is concerned, they've imposed the limitation.
Yes.
So I am concerned with an interpretation that removes that limitation from the equation.
We understand, Justice Chapter. We say that we haven't removed the limitation, we've met it, for the reasons I've given. That the citizenry meets that. It meets it because it shows that it needs the information in order for it to be an informed citizenry to exercise its rights to vote. And that relationship means that for the reasons we've given and with reliance on the court's decisions, we have met the limitation rather than avoided it.
You see, again, I'm struggling to follow the argument. I thought in your debate with the Chief Justice, you conceded that some voters may need it, others may not need it, and therefore, we don't know whether a particular person requires the information for the exercise of a particular right.
No, Justice Chapter, then I've been misunderstood, because in the answer that I was giving to the Chief Justice, I was speaking about it being an objective inquiry. It doesn't matter whether a particular set of voters in the Northern Cape need this more than others, and therefore they've made out the right. We are saying, as an objective inquiry, the citizenry across the country, for the reasons that have been given in Ramakatse and Mail and Guardian and in Bremer, know that information is necessarily required for them to be an informed electorate. And so, across the board, there may be people afterwards who say, well, I didn't want this information, but that's not the test. The test isn't whether a particular bunch of people say, I don't need this information, and thanks for having got it for me, but frankly, it's a waste. The question is whether, as an objective inquiry, the citizenry need it. And for the reasons we've given, which I don't want to repeat, we say that we've met the limitation rather than avoided it. And so we've met it in the way in which we say that the information needs to be disclosed continuously by political parties. So political parties have a duty to continuously record the information, because
Simplify that and make it practical for me, to understand exactly what is it you require of political parties to do.
So, first of all, it's clear that for the reasons that I was giving earlier, Chief Justice, donations might be secret, they might be made in kind. So, the only way to avoid that, the only party that knows which donations are being received is the political party. So, therefore, the obligation should be on them to continuously record the information.
What do you mean by that?
Well, to keep a register.
Or they must enter every donation that comes in.
So, Chief Justice,
And
just to give an example, and there's a very helpful analog in the Public Funding and Represented Political Parties Act, the Act which you know of 1987, which deals with public funding for political parties. It's a very useful analog because if one has regard to the modalities for how public funds are to be recorded by political parties, you'll see that this idea is easily translated into the realm of private donations. If you have a look at Section 6 of that Act, it says that a separate bank account must be kept for donations, as an example. Section 6B says there must be an accounting officer appointed by the political party to deal with donations. Section C says there must be separate books and records in relation to the money and all transactions involving those monies. And then Section D says that these accounts must be audited. All of that recognizes that it's not a difficult system to put in place. You're receiving the money, you've got somebody that must check that this is money received, there must be a bank account into which it goes. And obviously, the money is received not on one particular occasion during the year. That's not how donations come into the parties. Donations come in and can come in on any given day of the year.
Sure. So as and when they come through, they must be recorded.
That's
What
why we
about
talk about a
disclosure?
continuous. That's why we talk about a continuous recordal.
What about continuous disclosure? What does that mean?
What we mean by that is that there is an obligation on the party to continuously have that information available for disclosure. And how that might be done is, and this is where we use the word systematically, it must be done systematically.
No, I don't understand. just make it easy for any South African to understand what you are saying.
So,
What does it mean, continuous systematic disclosure? How must they disclose? And to whom must they disclose?
so in this context, Chief Justice, remembering that we don't want to prescribe precisely what the modalities are, it's for Parliament to determine this. But as an example, the disclosure we say must be systematic, in that it must be regular. Could be that it has to happen on a quarterly basis throughout the year, given that it's now been recorded continuously.
Who do they disclose to?
Well, it could be disclosed to a particular commission that might be appointed, as there is, for instance, in respect of the public side of the funding. It could be that it must be disclosed on a website, generally, that the political parties must disclose. We don't want to determine exactly what those modalities look like, precisely because this is something for Parliament to determine.
No. I understand that it's for Parliament to determine, but I want to understand it. For instance, if we move from the premise that everybody who is a voter would be entitled to that information, and you say website, I'll tell you, my mother doesn't know what is a website. So how are you there? Many villagers from where I come don't even know what is website. So how are they accommodated then in that disclosure that you say everybody ought to benefit from?
No doubt, precisely because of that question and those inquiries, that's a modality of the system that will have to be worked out by Parliament. So we don't prescribe to Parliament for a moment how it should be done to ensure that every elderly person versus every socially advanced, technologically advanced person. No, we don't prescribe that. What we do say, though, Chief Justice, is it has to be systematic.
You know why I ask? Because I don't understand that systematic. And it may well be that there is room for saying it's enough to record. And let whoever wants information that is recorded come and ask for it. But if you throw in systematic without even a proper appreciation of what that systematic entails, it could create problems even for Parliament. Oh, they say systematic, what do they mean? And we don't ourselves even understand what that continuous systematic disclosure means.
Well, Chief Justice, it would be difficult for Parliament to proclaim that it doesn't understand because it's already got the analog, as I've highlighted, in the Public Funding of Represented Political Parties Act, where it knows how the recording must happen.
And the disclosure?
The disclosure in that context.
Are they disclosing continually and systematically?
No, those are,
so they have a sense of what that means?
No, they're open for inspection. So
exactly.
But the importance
Can I just, I'm sorry, I'm interrupting you a lot, but I'm sure you don't mind.
No.
You see, that's exactly the point. If they are recorded and they are open for inspection, that ought to mean whoever needs that information, whoever believes that he or she requires that information, would then approach the political party and say, where is that book in which you record things? I want to have a look at it. And then they can be asked why. Once satisfied that the requirements are met, the book will be made available to whoever needs it. Rather than come up with a terminology systematic, when in fact we don't know what the parameters and actual meaning of that systematic disclosure are.
Well, Chief Justice, as an example, I mean, this court in Grootboom was quite happy to tell the government that it had to impose a systematic, what it called a plan-approved option for the way in which it was going to realize the right of access to housing. It didn't stipulate in any way what that meant, but we've debated this ourselves. What would it best be, by way of a word, to describe what Parliament must go and determine? And we've limited it to a systematic approach, in that it has to be, first of all, a system, so they must have agreed on it. Secondly, it must be a system which allows for there to be equal treatment of all political parties. The reason you want a system is so that it's not a particular burden on one party versus another. It needs to be a system that's imposed uniformly upon all the political parties. And it has to obviously be, in some respects, we know this from the language of the law, it must be a rational system, which does best give effect to the right of this access to information, given that this is the citizenry that they are wanting to ensure will have this access. Whether that would mean enough, for example, to simply have it published on the website of Parliament, whether it's enough to have it published on the website of Parliament plus political parties, we would think, frankly, in this day and age, that that would be the minimum that could be expected. It's not difficult to do. Put on the website. There's a parliamentary website. If that is information that is publicly available, it may mean that some people who are able to access it are perfectly satisfied.
Is there a comparable democracy that does it the way you propose we should do, so that we can at least examine that continuous systematic disclosure that you are proposing should be embraced by South Africa?
Chief Justice, the best that we've been able to do is give effect to what we see is already in our own legislation in the form of the Public Funding of Represented Political Parties Act, because it's, as we say, it's the best analog for what a disclosure mechanism would look like. You must record, you must have separate bank accounts, you must have an audited official that looks at it. That is a system. As to disclosure itself,
yes.
We haven't found anything comparable.
And maybe that's where the problem is.
Yeah.
I suspect if Mr. Masuku were to agree with you on the recordal, absent this difficult term, continuous systematic disclosure, maybe there wouldn't be much to fight about, actually. Maybe. But I'm grappling with that, but I've heard you.
Thank you, Chief Justice. So in our submission, we think there is helpful...
Mr. Du Plessis, if I may just interject. Do I understand your case correctly that you say the need for greater openness and transparency entail that there should be a continuous and systematic disclosure of private funding information?
Yes, Justice Kempepe. That is
and that systematic means there must be a system which is followed continuously.
Yes, exactly. And at the very least, that system, we say that it's for Parliament to determine exactly how that must look. We are aware of the fact that this is going to engage issues of exactly how the system might be built and exactly what the regularity of the disclosure should be. We accept that that is something for Parliament to determine, but at the very least we would say that the information would have to be relevant, it would have to be complete, it would have to be up to date, and it would have to be easily accessible. We put it no higher than that because we think that Parliament would do its duty in this context, recognizing that this information could be easily disclosed on a website, it could be easily accumulated by political parties. And there's really no magic in the question around continuity and systematicity. Those are ideas which have a sufficient elasticity to allow for the programs to be built into them, but which at the same time don't offend the separation of powers, which tell Parliament you've got to do it in this particular way. We've been alive to that concern in that context. If I might, this is a very helpful point, which I think in some respects I wish to draw to the Court's attention, because the public funding of political parties information is indeed disclosed on a continuous basis through the Represented Political Parties Fund. And there are reports which are administered by the IEC, and the reports are available on the website. So it's an answer, doesn't explain how often it has to be done, but it's exactly the answer I was attempting to give earlier, which is that it's not difficult to imagine that this is precisely how either through a commission or the IEC or the parties themselves or Parliament, you would have a space in which that information would be posted and would be available and would be updated on a regular basis, in the way that Parliament, frankly, already updates its website on a regular basis. So we don't think that this is a particular issue of great difficulty for Parliament. Quite the opposite, we think that it could be dealt with a measure of ease in the context. So
Before I forget, how much should be disclosed? Is it a large amount, any amount? If they do an Obama thing of $2, that must be disclosed. Where is the cutoff line? Is there going to be a cutoff line, or are you going to leave it to the wisdom of the lawmakers to determine what deserves to be disclosed?
we at this point in time would say no more than there is the principle of all donations must be disclosed. How the limit is set, Parliament will have a debate about that. But certainly at this point in time, it would be in respect of all donations. As I was saying earlier, even the 100 Rand that is donated by Mr. Dlamini and the 150 Rand that's donated by Mrs. Jones to whichever political parties, it's not a question of whether it's just a small amount. It's being able to understand the aggregated effect of that, to understand that there are sufficient numbers of donations, and when they all add up in a particular way, towards a certain party for a particular reason. And that information necessarily requires disclosure on that continuous basis.
I'm not too sure, but anyway, it's fine. I thought we were trying to avoid a situation where entities or people are able to influence political parties in a particular direction.
Yes.
Big funders are ordinarily those that have the possibility of influencing political parties' policy directions. I don't know if those who give 100 Rand, unless they have organized themselves in a particular way, but are pretending to be disconnected, have a possibility of having that influence.
No, Chief Justice, it's an important point, because it's not just the ability to, in fact, try and influence the political party. It's also to know what type of political party and what its interests are that people are voting for. So in the Obama campaign, for instance, $1 was enough to be able to give to President Obama, because $1 million of those $1 added up. Now, if $1 million of those $1 are given by a whole range of people, either clustered together as associations or individually, and they all do so because they think that President Obama is going to further a pro-poor objective, then if I know that information and I have pro-poor interests at heart, I'm going to think, well, I'm hoping that President Obama will be a pro-poor president. I am happy with him.
Or a xenophobic group.
Indeed, whichever way. So it's the aggregation of that information which gives an indication of where that political party might go, and why we say it's very dangerous to think of only 100,000 Rand or more, because yes, that's a big donation, it may influence, but it's the smaller donations very often that together accumulate and give an indication in the way that I've suggested. So those are our submissions, Chief Justice.
Before you, sorry.
Before you sit down,
Yes, Deputy Chief Justice.
in the High Court, you sought 2 declaratory orders, if I recall correctly, one of which was that Pyre is inconsistent with the Constitution to the extent that, I'm using my own words now, it didn't cover the recordal and disclosure that you are talking about.
Yes.
And then you sought an order that would suspend that order.
Yes.
Now, why do you need an order suspending that order?
Well, it's because we want to allow Parliament the opportunity to do the necessary amendments for purposes of achieving the declaratory relief. And we've, Deputy Chief Justice, we've relied in that context, and we drew up the relief in this manner, directly bearing a relationship with the way in which the order and the relief was sought and ultimately granted in Glenister 2. And if I give to your to the court, paragraph 248.
Well, before you go
Sorry.
there, I just want to have this clear in my mind, and it may well be that in some judgments that's how we have dealt with similar situations. But the constitutional defect that you rely upon is an omission by Parliament to include certain provisions in Pyre. Now, if there is an order, the order of invalidity really should not say that Pyre is inconsistent to the extent blah, blah, blah. It should it not simply say the omission to include X, Y, Z in the provision of Pyre is inconsistent with the Constitution, because really it's the defect that you are concerned about.
Yes.
And to the extent that the complaint is about an omission, what is the harm of an order that says that omission was unconstitutional or is unconstitutional? How does it prevent Parliament, if it is not suspended, from doing its job to make sure that Pyre is appropriately amended?
Well, two steps to the argument, Deputy Chief Justice. The first is, of course, that for the reasons that we've highlighted both in the oral submissions and our written submissions, Pyre is defective in a number of ways because of its inconsistency with Section 32 as read with 19. And those constitutional deficiencies are, in the judgment that this court will write, deficiencies that will be highlighted. And to the extent that those deficiencies together and the architecture of Pyre means that, if we are correct, that political parties and their private information are not properly covered by Pyre as should be required under Section 32, then the declaration that we seek of invalidity would be a declaration of invalidity in relation to Pyre, its architecture, and all of those particular difficulties, which ultimately, at the end of the day, we say would then mean that this court has the declaratory relief that we require. And then separately, because, again, we don't want to be imposing any particular scheme by which Parliament must go and fix this, and we don't wish to push the court to a situation where it is stepping over the bounds of what Parliament is entitled to do, we would wish for the declaratory relief in relation to Pyre simply to be suspended so Parliament can do its duty.
I don't think you understand the Deputy Chief Justice. You see, if you declare legislation, for instance, in terms of which firearms are granted or licensed, constitutionally invalid, and then you suspend, or let me give you an example of what happened here. A magistrate being responsible for the issuance of licenses or their renewal. Then we declare that constitutionally invalid. Then we suspend the declaration of invalidity for a period to allow Parliament to fix the problem. We have to suspend so that in the meantime, the declaration of invalidity does not stop people from getting their licenses either issued or renewed. Something must be able to happen that would otherwise not happen had we not suspended. Now, if you are saying Pyre does not provide for the disclosure, what will happen if you don't suspend? What are you suspending for? What harm are you trying to prevent by suspending the declaration of invalidity?
Only the separation of powers harm that I was
How?
mentioning. Because it would mean that if you simply had the declaration of invalidity as it stood, then Pyre would be declared invalid to the extent that it doesn't allow.
Yes, and then what will flow from that? What would be the consequences?
Well, there would be confusion, firstly. Because,
How?
Because nobody would know, is Parliament now going to go and fix this problem, or is it simply permissible for you to now claim that you're entitled to this information without having to wait for Parliament's job?
What will happen flowing from the declaration of invalidity is that it will be business as usual. People won't have access to information the same way they never had access to information, but in the meantime, Parliament will start doing its work.
Yes. In that
So
sense,
the suspension is meaningless.
it's not meaningless in as much, Chief Justice, as there is an effort, obviously, over the space of time to get Parliament to have effected this legislation. And the main difficulty, of course, has been that there hasn't been a proper understanding of Pyre and whether it covers this. So there's been a challenge brought by My Vote Counts. It was in this court. Ultimately, it was sent back, and it was told, you must challenge Pyre. And Pyre was challenged. Now we're back here, and we're asking for the confirmation. In order to ensure both that Parliament's role in this process is respected and to ensure that Parliament does its job in order to ensure that there is not just business as usual for months on end and years.
How do you make that sure by suspending the order?
It's suspended for the purposes only of that period of time, Chief Justice.
To achieve what?
Well, we see the difficulty that's been raised, but we see the difficulty. But I've given the answer that the reason the suspension is there for that purpose is to ensure that Parliament does its role. But we see the difficulty, Chief Justice.
Mr. Du Plessis, I have a related question. It's something I've sort of grappled with throughout. In my vote counts 1, the majority held that Pyre is intended to cover the field.
Yes.
Parliament is now set about the job, not of amending Pyre, as I understand it, but regulating funding. Presumably, it's drafting a bill, and which will become an act, where it will now purport to cover the field. Now, we're sort of writing a judgment, and we don't want to complicate what Parliament is doing. Is Parliament now going to have to amend Pyre and deal with the new bill, or can they put everything in the new bill?
We would be happy either way, frankly.
No, but I'm talking about the, sort of the practical issue, because what this court says will come in the way of a directive.
Yes.
So, for example, if the court simply said that to the extent that Pyre or any other legislation does not provide for this, it's unconstitutional. That would be one way. But if it says to the extent that Pyre doesn't regulate it, the first thing a parliamentary drafter is going to consider is, do we now need a whole chapter here in Pyre dealing with the problem?
Yes. Yes.
So we need some help, at least I need some help on that problem.
Yes. And we would see it, Justice Kachalia, as precisely that possibility of those two options. But because this court in the majority said that Section 32 and Pyre are the relational rights and statute, and that we must go and challenge Pyre, we have now done that. Now we're before this court, and there's not much that can be done other than for confirmation of the invalidity in respect of Pyre. If that invalidity in respect of Pyre is then confirmed by this court, then absolutely the legislature will have to ask itself questions. We were on a particular path dealing with this bill. Now that there's this declaration by the Constitutional Court, how do we fix Pyre, either in conjunction with that bill, or do we scrap the bill and start again in relation to what we're doing under Pyre? We see that those are potential difficulties for the legislature. All that it would do, though, with the greatest respect to them, is they would read the judgment and they would take very clear cognizance of what the difficulties are in Pyre. And if they had to remedy it, they'd remedy it. We don't see that that would be an impossible thing for them to do in conjunction with the bill that they've already passed, the bill or the bill they've already drafted. The two could easily be done together. How they do it, we don't want to prescribe, and with respect, we don't suggest to the court that it should prescribe, which is going back to the point of why we've wished to ask for a remedy around Pyre and the Section 32 rights, and which requires that there is, at a level of continuity and systematicity, an obligation imposed.
Mr. Du Plessis, sorry, just one last question. At a practical level, help me understand, at what stage does the duty to record and disclose arise for a political party?
Well, we would say that the duty to record is continuous. So if this court writes a judgment which says that under Section 32(1)(b, all parties have to record this information, then that would be an obligation that they would have continuously in the manner in which I described. They'd have a bank account, they'd have records, the money would come in, and they'd record it on a continuous basis. There's a separate debate about when they would have to then disclose that information that they've been recording. And that's the system that we were speaking about. How often, whether it must be on a website, whether it must be on a parliamentary website, whether it must be done through the IEC and reports, is something which ultimately, at a practical level, will be ironed out by Parliament in its own time.
Does a political party have, or does the duty get triggered as soon as the political party is registered?
We would say yes, with the registration or the independent ward candidate being in power, that would, or standing for the position in concern, that would be when it is ultimately triggered. The registration would be when you are, as a political party, then recognized within the scheme under the Electoral Act. So that's when you would, as a political party, have this obligation. Certainly, it would be from that moment onwards.
And the disclosure, would the disclosure, the obligation relating to the disclosure also kick in at what stage? That you need to start continuously disclosing.
Yes, when you register as a political party, as part of that, you would have to open a bank account, you would have to appoint an accounting officer, and any donations from day 2 after day 1 when you became registered would then have to be recorded. When it would be disclosable is, as I've said, part of the debate about systematicity.
Well, I'm asking this question in the context of the reason for which this disclosure is required. I was just thinking, parties like the South African Communist Party, which does not participate in the elections for either membership in national parliament or provincial legislatures, are they bound to disclose?
We have come to this court only in respect of political parties, Justice Jafta. The political parties are those that are registered. And for purposes of this case, that's where we are seeking the relief we do. There's a separate debate about associations like COSATU and others. That's a fight for another day.
I thought the Communist Party is a political party.
Yeah, it's a political party, but it's not registered. You can't vote for it. And remembering our fight is about the right to vote. I want to be able to get the information so I'm an informed voter in respect of that party.
Well, another example would be that of, is it NFP, which was disqualified from participating in municipal elections. So if a party will not, even if registered, will not participate in elections, would it be bound to disclose?
Well, on the assumption that it may later become able to contest future elections, yes, it might be that it was disbarred from, or barred from one particular election, but when it's disbarred and the potential arises again, well, then it may well be. Those are mechanics with respect, Justice Jafta, which are to be ironed out in due course. But at the level of principle, if they're registered, yes, they must disclose. They don't get to have an amelioration of their obligation just because they happen to have been kicked out of a particular election. We wouldn't have thought that that would be a rational basis to exclude them from the obligation. So it's left for me to say, Chief Justice, that we seek confirmation on the cost of 2 counsel.
Thank you, Mr. Du Plessis. Mr. Masuku, the court will adjourn for about 15 minutes, and then you can make your submissions afterwards.
Thank you, Chief Justice.
Thank you. The court adjourns.
To explain some of my notes, I can run to the ladies, please.
we do not suggest that private information is irrelevant in the broader political considerations of how people engage with information when they decide to cast votes or when they decide to belong to political parties. We say that it's not just to isolate private funding for specific constitutional recognition is in a sense a limitation of the spectrum of information that is required by a voter to decide how to vote. As was put pertinently by the Chief Justice, some voters don't actually need information to vote. So the declaratory order sought by the applicant, and which was given by the High Court, elevates private funding to a special type of information and affords it special constitutional recognition, which we say can only be done or may only be done where there is constitutional ambiguity relating to the value, the importance of private funding information. We understand the value of private funding information, but we also understand the value of other information. There is the evidence we submit demonstrates demonstrates how unnecessary it is for this court to grant a declaratory order in the terms that are sought, an order that to the effect that specific type of information is important for the right to vote. Is that we've had elections from 1994, all of which were conducted under a dispensation where there was no specific recognition that private funding may, for the role that it plays in the political environment, deserves a special constitutional recognition in the terms of the order that the applicant seeks. Let me get back to the question that I said I would start with. When my learned friend responded to that question, he pointed the court to the public funding of Represented Political Parties Act. And he said the system of accounting and disclosure that is set out in that particular legislation would be a helpful reference point in how one determines or how one sees this whole recordal and disclosure of private information regime that is sought by the applicants. What is important from that answer is the recognition that the source of constitutional authority for the obligation to regulate party funding is not Section 32, because that particular act is an act promulgated in terms of Section 236 of the Constitution. And if one looks at Section 236 of the Constitution, it specifically says, to enhance multi-party democracy, national legislation must provide for the funding of political parties participating in national and provincial legislatures on an equitable and proportional basis. Now understand that this regime of legislation envisaged here only regulates public funding, of political parties that are represented in the respective legislatures. But would submit that the obligation to regulate funding of a private nature is not, that obligation, as far as Parliament is concerned, could be covered in that particular legislation. That particular legislation, although relates to political parties that are represented in Parliament, is a source of authority for Parliament to look at how funding can be used in order to enhance a multi-party democracy. And so we would say that provision in Section 236 read together with Section 19 are the sources in terms of which political parties may be regulated. And the resources that political parties require in order to meet their constitutional obligations under Section 19 would be regulated in terms of that, in terms of that provision. I understand the response of my learned friend to that particular argument. It's that we are here for access to information. We're not here about anything else. We want a regime of access to information in terms of which a specific obligation is placed on political parties and independent candidates. We want those two to be subject to a regulatory regime in terms of which there is an obligation on them to record on a continuous basis and on a regular basis to disclose private funding information. As I point out, Parliament is already doing that. Parliament has already recognized the importance of private funding. They are already engaged in a process of ensuring that such a regime of party funding which governs or which regulates how private funding is dealt with is actually in place. So we are not in a conflict with the applicants, and as far as that's concerned, at level of principle. Where we are in conflict with the applicants, and where we would seek this order to not confirm this ruling, this order, is when they say that the source, the constitutional source of the obligation to disclose private funding and to record it is Section 32. We, and more specifically Pyre, which regulates obviously the right that we contend is a very important right as well. So we would say, if one then wants to engage with what the applicants are seeking to do, one must go to the order that was sought and the order that was granted, and determine whether they have not fallen foul of the sin that was identified in my vote counts, my vote in majority judgment of my vote counts 1, in which it was specifically required of them to challenge Pyre, not to challenge it on a broad spectrum. They challenge Pyre, a specific provision, for example, a provision that the definition of political parties as provided for in Pyre is inadequate to the extent that it does not provide, it does not cover political parties. That's a direct challenge to a constitutional provision that they contend is unconstitutional. So when Parliament is faced with that declaration of constitutional invalidity, Parliament knows exactly where the constitutional defect is, and Parliament is able to address it. Challenge, for example, the limitations that are placed on the access regime that is provided for in Pyre, specifically the Sections 50 provision that Justice Jafta referred to. Because then you are challenging Pyre. What has happened here is this. The applicants sought essentially 2 declaratory orders. The first declaratory order is, as I say, would have to be anchored on the basis that they are able to show that there is constitutional ambiguity relating to whether private funding is in fact a part of the class of information that must be isolated for this kind of recognition by this honorable court. So they wanted a declaratory order which they got, that information about private funding of political parties and independent ward councillors registered for elections for any legislative body established under the Constitution is reasonably required for the effective exercise of the right to vote in such elections and to make political choices in terms of Section 19(1), 2, 32, and Section 7(2) of the Constitution. They also then sought a declaratory order that that the Promotion of Access to Information Act is inconsistent with the Constitution and invalid. Why? They say insofar as it does not allow for the recordal and disclosure of private funding information. It's fair enough that in their affidavit they identify the defects that they say Pyre suffers from, and they say the definition of Pyre is inadequate. But they don't specifically challenge that as being unconstitutional, or they don't require you, as the Honorable Court, to set aside that definition in Pyre as constitutionally invalid to the extent that it does not accommodate political parties. They don't ask for a declaration of constitutional invalidity of Section 50 to the extent that it imposes what they would say are unreasonable or unconstitutional limitations to the right of access to the private funding information. So what we're faced here with, and which this court is being asked to confirm, is an order of constitutional invalidity to the extent that Pyre does not allow for recordal and disclosure of private funding information. Now, we've got to explore whether, in fact, that is true, that Pyre does not allow for the recordal and disclosure of private funding information. But before we explore that, we've got to ask ourselves whether or not it is it is an obligation that arises from Section 32, that Parliament had to specifically require political parties to record and to disclose private information, as they now want to seek to amend that order on a continuous and regular basis. Let me then deal firstly with the main arguments that I intended to deal with, which relate to the constitutional the declaratory order number 2, which is the declaration of constitutional invalidity, to the extent that Pyre does not provide for the recordal and disclosure of private information. The Pyre source is Section 32, and the recordal and disclosure the recordal and disclosure obligation must come from Section 32. We must go to Section 32 to find out whether from Section 32 there is that obligation that the applicant seeks to impose on Pyre. Section 32 guarantees the right of access to everyone. And that's very important for the argument we advance. Because in the debate that the court had with my learned friend, it's quite clear that the dispensation that is sought by the applicant would result in a situation where anyone who has a right under Section 32 may have the right of access to private funding information, as long as they can show a right that they need to protect or advance.
While you are there, the 10 minutes is up. I just want to try and, through you, seek an answer that I needed from Mr. Du Plessis but couldn't get it. Beginning with Section 32, you see, Section 32, 1B. Everyone has the right of access to any information that is held by another person and that is required for the exercise or protection of any rights, not just constitutional rights. Now, is it not open to a member of the public, even the one who doesn't want to vote for a particular party, or even a member of the media or member of another political party, to come and say, I want this information from you, ex-political party, for the following reasons. And then it takes you to Section 195 of the Constitution and say, I'm entitled to public office bearers and to a government that does the following. And before I tell you what that or those public office bearers or that government is required to do, I need to be sure that there is no reasonable possibility of you people as a political party that might win being compromised and therefore beholden to funders who may wish to use you, so that you focus on their interests and not the interests of the public. And then it goes to Section 195 and say, it says basic values and principles governing public administration. And public administration is broad. Public administration must be governed by the democratic values and principles enshrined in the Constitution, including the following: a high standard of professional ethics must be promoted and maintained. So you people are not going to be ethical if you are compromised by funding, because the one who made it possible for you is going to call the shots. It's going to tell you not to be unethical if it suits it, him or her, that you be unethical. And then it says, be efficient, economic, effective use of resources must be promoted. So you see now, when compromised like this, when it comes to tenders, something that is worth 1 million rand will easily be cost to be sourced for 30 million rands, because you either toe the line or you risk losing the next election. And D, services must be provided impartially, fairly, equitably, and without bias. So the bias is settled by the funding. You are incapable of living according to this principle of value, because your idea or your possibility of doing the right thing depends on how much the funder permits you to do, or to what extent you are allowed to deviate from his or her or its dictates. People's needs must be responded to. Responsiveness, that is a value under Section 1. Public administration must be accountable, that's F. G, transparency must be fostered by providing the public. Now this is very interesting, this G. Providing the public with timely, accessible, and accurate information. It's one thing to provide it at state level, but I want that information all the way, even at party level, because that may even determine whether you are going to give me you're going to give us as the public credible people, competent people, or people who are capable of being tossed one way or the other by the funders. Why ought it not to be open to another political party, member of the public, to say, you see, becoming government doesn't start with being there already. As a political party, or even individual independent candidates, you have the possibility of rising to that level. But we've got to clear the decks much earlier before you even have the possibility of campaigning. Show us now what kind of a person you are. Are you compromised or not? Why can't that be extended to the right issue that is in 32(1)(b) to say, as a public, I have the right to ensure that whoever has the possibility of getting there would be able to do that which is required of a public servant, of a government functionary, and so on and so on. Why is it not capable of that, of being stretched to that point?
Thank you, Chief Justice. The answer I can come up with, Chief Justice, is simply based on the scope of the right in Section 32. The right is subject to, firstly, an internal limitation. The internal limitation in Section 32(1)(b) is that, firstly, before you even exercise the right, that information must be held. It's information that is held by somebody. So that information must be existing. And secondly, that information must be required for the exercise or protection of any right. That's the limitation that would guide a requester of information under Section 32. But there is also the further limitation on Section 32. And that limitation can be seen in Section 32(2). Because Section 32(2) then says, national legislation must be enacted to give effect to the right and may provide for reasonable measures to alleviate the administrative and financial burden on the state. So what the Constitution envisages is that when you wish to exercise your right under Section 31(1), you then go to the legislation itself, which which is enacted to give effect to this right?
But why can't they say, Pyre is that national legislation, but Pyre, broadly speaking, fails in this respect.
I beg your pardon, Justice.
And why can't they argue that Pyre is that legislation that would facilitate my access to information? But I'm here to say, Pyre has failed me. Pyre does not facilitate the holding of that information. And it's an empty promise to say I have access to information which is critical to the exercise of my rights in circumstances where there is no mechanism to ensure that critical information of this nature, which comparable jurisdictions do make provision for it to be held, is not held at all. So why can't they argue and say, look, I'm focusing on Pyre now, but whether Parliament wants to make provision under Pyre, all the necessary provision, not only for accessing information, but the recordal as well, that's fine. All I want is information must be held. But it's open to Parliament, I accept, that it may decide to have the recordal procedures or responsibilities under another legislation. That's okay, as long as Pyre can also be crafted in such a way that that information, wherever recorded, I can, through the operationalization of the Pyre provisions, be able to access it. But the bottom line is there must be provision made for information to be recorded or held so that it can be accessible. Otherwise, it's just a pipe dream to say that you can have access to information for the purpose of exercising or promoting any right when this particular right is incapable of being properly exercised or provided because that information, it's not obligatory that information be held, although it must be held.
So the
Maybe I spoke for too long. You may well have, I may have well have confused you. So in the first place, they may say you can spread it. The Parliament can split it to another legislation such as the bill, but whatever they do, Pyre must also allow me access to that information. That's up to them how they do it. I just want information. I just want to have access to it, but it must be held.
Thank you, Chief Justice. But the factual basis for that you've presented to me, Chief Justice, would be a very good basis for doing what this court called the frontal challenge of Pyre. So attack Pyre, because Pyre is supposed to be the legislation that gives you access to information. But you have identified in Pyre that you are not able to get that information because Pyre is structured in such a way that you need to comply with a certain procedure, and your argument is that that procedure is not foreshadowed in the Act, in the Constitution itself. Section 32(1) does not envisage that there would be a procedure. So you can simply, if there was no Section 32(2), you could simply access Pyre based on Section 32(1). So it's possible for a requester to say, I'm not able to access, to use Pyre in order to exercise my right to access information, because your definition of political parties or your definition of private parties or public bodies does not accommodate the entity that I am. I'm an entity that doesn't fall within any of the two definitions. So you have restricted the scope that the Constitution allows for me, because the Constitution is everybody. Now, on what basis have you now regulated in such a way that only public bodies or private information as defined in Pyre are obliged to grant access? Now, of course, even that complaint itself must recognize that the limitation to the body with that responsibility is not necessarily per se unconstitutional.
While we are there, because I think we have the possibility of understanding each other and maybe narrowing it down. You see, the person is basically saying, Pyre is the legislation envisaged in 32(2) to make it possible for me to access information, even information held by a political party, to the extent of its omission to make that information accessible, considering that it is the mechanism that is supposed to make that accessible to me, or through which I'm supposed to access that information, it is inconsistent with the Constitution. At that level, without recording and so on, just at that level.
We would have no difficulty with that proposal.
Right.
It is perfectly...
Okay. Now they take it further. They say, you see now, I want to have access to information. You people have not, you parliament have not made that possible for me. No political party seems to have been envisaged by the legislation as it exists. Now we are agreed. There's another leg. These people are under no obligation to hold that information that I need under Section 32. But that information must be held somehow. They present their argument. Once the argument becomes acceptable, just at the level of principle, then we ought to be able to say that information must be held. Whether it is Pyre that is going to say so, or another piece of legislation, whatsoever it may be, that information is critical for the effective functioning of our constitutional democracy, because we want to fight corruption in any way possible. And then your argument, as I understand it, is, okay, yes, I agree this information is necessary. The Electoral Act or the Electoral Commission Act or another legislation is the most appropriate vehicle. Why are they not entitled to say, we agree with you? So, let us agree that the court must produce a judgment that says, it may be Pyre, it may be another legislation, but holding or recording must happen. Why should there be a problem?
No, with respect, Chief Justice, it has to be based on a constitutional argument that is reflective of our constitutional text. It must be based on the fact that when a requester says, the problem with Pyre is not that section, is not necessarily, just in terms of our constitutional litigation. The applicants are not here saying that declare section 1 of Pyre as unconstitutional. They're not here saying declare section 50 of Pyre as being unconstitutional. And they don't, even though they point the deficiencies that they identify, what they're here saying is that declares Pyre as a whole unconstitutional because it does not provide for a requirement that political parties must disclose and record and disclose information on a regular and consistent basis. So what we submit is that firstly they've got to show that they are unable to get the information under Pyre, and that they are unable to get that information under Pyre because of the identified defects that they have identified. We say that's not correct. They've not been able to show that they are not able to get information under Pyre. As your Lordship, as the Chief Justice would know, and justices, the factual situation presented by the applicant is that they used Pyre in order to try and get information from political parties. Well, political parties responded.
I'm sorry, I'm sure you understand we interrupt from time to time.
Yes, no, I'm quite
You see, Mr. Masuku, this is where I am. I thought we had found one another, although I'm not trying to persuade you or convince you, that there is room for saying that a political party does not appear to have been provided for by Pyre as an entity from which information can be sought or accessed through the Pyre mechanism. Now, if that is so, you then go to Section 32 and say it says held say there is no mechanism for holding, there is no obligation for holding even this critical information. So some kind of holding of information that allows me either to exercise my right to vote or even other rights not covered, because we can't close our eyes to constitutional rights that ought to be provided for within the scheme of 32 just because there is an omission on the part of the applicant. So we then say the right to vote. Then we also say, Section 195 is also a factor, meaning we ought to be agreed as South Africans that this is the kind of crucial information for good governance envisaged by 195 that ought to be held. There's got to be an obligation to hold. As to the mechanics, we can debate that, or maybe we can simply leave it to Parliament to decide how best to ensure that the information is held. So we can debate that, but the principle can be agreed on that it needs to be held, and the hold is in Section 32.
That principle would be consistent with our constitution. I do not suggest at all, and we're not at odds. We're not far apart on that point. The point that I make with respect to Chief Justice is that in order for one to make that case has to be made before you. That case has to be made. The case that has to be made is this: that Pyre, which is the vehicle through which I can access information, for all the good that access to information provides in the system of government and the constitutional democracy envisaged in our constitution, they've got to say it's defective based
Mr.
on...
Masuku, I'm sorry, I don't mean to disturb you, but let me tell you what I'm struggling to understand, all right? I know what your opponent's case is. What the Minister of Justice is here, he represents the government. So what is the government's problem? What is the government's case? Or what is its problem with the other side's case, which is we want information to have an informed electorate, and that information must be recorded systematically. Now, that's in a nutshell. It must be recorded and disseminated systematically. What is the government's problem? Does the government think there shouldn't be information at all? Or I'm not quite sure what I understand the technical arguments around Pyre and so on. But what does the minister want as an outcome here?
Justice Kachalia, you would have seen that there are two pieces of information, two pieces of legislation that are implicated that clearly demonstrate what the government's position would be. There is Pyre in itself, the legislation that is enacted in order to give effect to Section 32 of the Constitution. So the government is quite keen to have a situation where citizens are able to access information for purposes of exercising or protecting their right. The government is also very conscious of their obligation to ensure that they pass a law that provides for that system at its maximum level. So Pyre is one of the pieces of legislation that does that. The second aspect is that we did point out to, you already pointed it out, in fact, that Parliament is engaged at the moment in passing a law that specifically deals with that specific aspect of private funding information and how that should be regulated. So government is very, very conscious of its obligations under the Constitution to pass legislation that enables citizens to fully exercise their rights. There is no question about the fact that they are trying to avoid the applicants from accessing the information where they are able to to comply with the requirements that have been put down in legislation.
Well, back to my question now. The holding in Section 32. Why does Section 32 yield the responsibility on government to make sure that crucial information such as funding of political parties is held, so that it becomes accessible to whoever might need it for the exercise or protection of his, her, or its right.
My Lord,
Hold.
First,
We're trying to decolonize ourselves, not my lord.
no, and we're part of that project. In fact, government is driving that project of decolonizing ourselves and creating a state that complies with the Constitution. The impression that I would be failing in my duty, that should never be created, is that government is trying to avoid creating this disclosure regime. The point we're arguing is a legal and constitutional point. It is what is the source of constitutional authority for that duty?
I said hold in section 32.
Yes. And the answer I've given your Chief Justice is that section 30, Pyre provides for that. And as far as private funding information is concerned, we would say that what the Constitution envisages is access to information that is held, information that exists. I don't want to, I'm not sure whether I can stretch the argument to say that Section 32 cannot be regarded as a source of the obligation to generate information that doesn't exist.
No.
I'm hesitant to make that point.
Yeah.
But what I try and do is to look at Section 32 and look at the word held and see the word held as a word that creates a state. In other words, it says that information must exist. It does not necessarily create, Section 32 does not necessarily create the obligation to generate non-existing information.
Okay, let's deal with that, because really I need to understand that. You see, isn't there room for this argument that there is the kind of information that obviously must be held by reason of its by reason of the critical role or crucial role it plays in sustaining a constitutional democracy, or information that must obviously be held, information that nobody can be heard to be saying, but you've got to justify why this information must be held. And when Section 32 then envisages information that is held, is information on funding of private funding of political parties, not information of that nature, especially in a country like South Africa, where we've had a bit to deal with corruption, to the point of even establishing one commission or another.
Chief Justice, I don't at all suggest that proposition is not correct. But can I make the submission that it's okay and it's important for the government and for Parliament to recognize the value and the importance of certain types of information, and to isolate that information for special rules of disclosure and for regulation, because exactly the role that you say that information plays in holding together the constitutional democracy. But in doing that, the guiding principle, the guiding legal and constitutional principle, must be what the Constitution says. So if the court finds that this type of information is singularly important for the exercise of the right to vote, the government will have no problem with that, the order being made. Absolutely no problem. And I can concede that immediately.
Coupled with Section 195.
No, but no,
or any other right that we may think is relevant for this purpose.
So the court can go as far as it sees that obligation.
Based on Section 7.2?
Based on Section 7.2.
And in Section 7.2 as well.
We would Would say that's what Section 7.2 says. I mean,
So
Section
what is the
7.2
problem?
No, I don't understand the question, Chief Justice, because the problem, as I have put it out, is that the problem is that there is no constitutional lapse by government to pass legislation that complies with the Constitution. They've passed Pyre. Pyre complies with Section 32. What you have before, what the court has now, is an order that it must confirm. But what it is confirming is an order that says that Pyre, the reason why Pyre ought to be declared unconstitutional is because it does not allow for the recorder and disclosure of private funding information. But you've got to be persuaded that the Pyre does not do so. That's what I'm saying. I'm saying no argument has been advanced as far as I can remember that says Pyre excludes political parties from its reach.
Well, I've understood.
The argument is,
I'm sorry to interrupt you, but I've understood the applicant's argument. It was set out that there isn't a proper record. Pyre is deficient because it only refers to information that is recorded. It doesn't refer to donations in kind and so on, so it's deficient in that sense. It's deficient in that there's a gap because political parties fall between private and public. That's how I've understood the argument. Are you saying that Pyre covers all that?
Yes. We say, for example, there is absolutely no reason why a voter cannot go to a political party and ask for that information. They've done that.
I just wanted, what my brother is asking you about is will it be obliged in terms of Pyre to comply, or are people at the mercy of the political party because there isn't anything you can hold, you can put your finger on in Pyre that entitles them to that, to accessing that kind of information through Pyre?
My Lord, I mean, I wouldn't, I don't think that I can argue that there is a specific provision in Pyre that says political parties ought to hold the information on private funding. Pyre doesn't isolate political parties. Pyre simply gives rights, it defines who the scope of public bodies and private bodies that must give effect to the right to access information. What it does not do is to isolate political parties and say to political parties, you have to keep information on private funding.
So which word or which words would allow us to say a political party falls within this bracket or is accommodated by this word or words? In which word or words in Pyre should give us comfort that even political parties can, in terms of Pyre, be approached to disclose information on their private funding?
Well, Mr. Chief Justice, the definition in Pyre of persons, natural and juristic persons. So I understand the debate and the concerns that were raised in both the minority judgment of this court and the judgment, the Concourt judgment, which is here for confirmation, that the problem with the definition is that political parties don't fit well in those definitions. That's what they say. But I cannot understand. No, I did not suggest that it is wrong. I do not make the argument that it is wrong.
Let me, just so we clear, you say
Do you finish to answer me before you attend to my brother?
I hadn't finished the answer.
Please finish first and then you'll attend to my brother.
Yes. Thank you, Chief Justice. So the definition concerns that are raised in the majority judgment and in the Concourt judgment and our submissions are a bit difficult to understand. because political parties are juristic persons. They do have the power to sue and not to sue. Not all of them. Some of them have. The EFF has been here many times. The DA has been here many times. They are of such a nature that they would fall under the definition of persons in that respect. So we would say that, I mean, if the argument is that the special problem with Pyre is that it doesn't go far enough in as far as the definition of the in as far as that the definition of political party is not accommodated, then that's not an argument with respect that warrants the order that was given. The order that was given is that problem with Pyre is that it does not provide for a disclosure and a recordal requirement on a consistent and regular basis. It has nothing to do with the name, with the coverage. That, in fact, order presupposes that political parties are, in fact, covered under Pyre.
Have you answered my brother's question, or are
No,
you
no,
now
no,
attending to it?
Justice Kachale had not finished his question before he was about to clarify.
I think from your answer, it does appear that you are arguing, when you say that the minority's judgment that there's a gaping hole in Pyre adopted by the High Court, you say it's difficult to understand, but that's a nice way of saying that it was clearly wrong because registered political parties are covered under the heading of juristic persons.
Yes.
So
That's
your
right.
argument is that it is wrong.
Yes.
Yes.
We would also then say, because I'm absolutely want to make it clear the reason why the minister is here. The minister is here because his concern is the invalidation of Pyre on a basis that there is no recordal and disclosure requirement. On the disclosure requirement, we say that's not correct. The disclosure requirement is there. If we are correct that political parties are juristic persons, the disclosure requirement is there. What they're asking for is an order in terms of which this disclosure is not subject to any limitation. This disclosure requirement is not subject to any limitation. That's their problem. That even if we were to accept that political parties are juristic persons and therefore subject to Pyre and could in fact be ordered to disclose certain information, the problem is that disclosure requirement is subject to the political parties themselves saying, this information is of some nature, the limitations that are in Section 50. They could invoke them and so avoid disclosing that particular type of information. But
what happens if we come to the opposite conclusion, that it's not a juristic, registered political parties are not juristic persons, and that the minority judgment of this court was correct in saying that it does not sit comfortably with either definition? What is your argument then?
The problem is you don't have a constitutional challenge that is asking you to specifically say that the problem with Pyre is that the definition is not wide enough. So we don't say that Pyre. So the argument I just lost my trend a little bit. But the problem that was presented by the applicant is a problem that Justice Jafta kept on raising about the role of the limitation. Firstly, the role of limitation in Section 33 itself, sorry, in 32 itself, and the limitation that is contained in Pyre. The limitations that are contained in Pyre, can they be said to be unreasonable limitations? To the extent that when they define private bodies, that definition doesn't, if on the assumption that political parties didn't fit the definition of Pyre, could we say that that is not a justified exclusion of a private body from the reach of the disclosure requirements? That's something that would be an interesting debate in another case. But on the assumption that political parties are not defined under section 1, under the definition section of private bodies or public bodies. On that assumption, then of course, you must have a proper constitutional challenge that addresses that specific issue, which the majority judgment specifically raised. What has been challenged is that there is no recordal and disclosure requirement. I can't stress that enough, because that's the order which you asked to confirm. But
Masogo, I'm sorry. As I understood Mr. Du Plessis' argument, relevant to this aspect was, Pyre was enacted to give effect to the rights in Section 32. The procedure outlined in Pyre is not workable to give effect to that right in relation to the right to vote. You cannot expect every voter each time to fill in the form and request information for the information to be available. You must have a system that has the information there available and accessible without filling forms each time. What do you say to that argument?
As a constitutional, as a submission based on the Constitution, I would say there are problems with it, because then it doesn't accommodate the limitations that are built in it under Section 32. A read to Section 36, because the impression that the right of access to funding information is a right that is not subject to any limitations. To require the disclosure requirement contended for by the applicant would be problematic from a constitutional point of view. It may be a nice thing to have from the point of view of developing our democracy to a level that is beyond what we could dream of. But when we are looking at what the Constitution says, then we ought to be able to say the Constitution does provide for legitimate limitations to be placed on the right of access to that type of information. And there is also another reason why the limitation would be very important, or the limitation regime would be important in as far as that information is concerned. Because when people donate money, whether it's 5 rand or whether it's 100 million rand, it's a possibility that that donation is made as an expression of the very political right that is protected under Section 19. Section 19, with respect, says 19.1c. It says every citizen is free to make political choices, which include the right to campaign for a political party or cause. So when someone donates money, it may well be that they are in fact involved in that particular expression. It's an expression of their support for the political party. You know? And so they are giving resources to a political party in order for that party to champion the cause that is protected under the Constitution.
You know, Mr. Masogo, a thought just struck me. Why should this not be treated, this readiness to disclose information, not be treated in the same way as the disclosure requirement for judges and parliamentarians and members of the public? Doesn't that, or ought that not to say to us, there is a particular kind of information which ought to be readily available to the public, because failure to make it readily available to the public facilitates or enables corruption to creep in. So, just as judges, just as magistrates and parliamentarians and members of the executive are required to readily disclose and have the information available to whoever wants it, so should it be with political parties that are not too distant from the public space and not too distant from activities that actually affect the constitutional rights or the lives of the people. So isn't there a principle already that makes it acceptable that these people should actually be volunteering information rather than make it difficult for it to be accessed?
No, as I submitted earlier on, Chief Justice, I would never quibble with that kind of proposition. I only make submissions that are intended to assist in how one analyzes the scope of the obligation that you put to me. So what the example that you're giving to me is a very apt example. But it must be bear in mind all the time that government has accepted that the regulation of political funding, private political funding, is a necessity. They are doing that now. The reason I'm here is because there is a challenge to an Access to Information Act on the basis that government has not done what it is currently doing now. So the proposition you put to me is something that has already been accepted by the legislature. They are already doing it.
Well, before I forget, just there, government had initiated a process that could address this issue. But is it seeking to amend Pyre?
No, it is not seeking to amend Pyre because the understanding of government is that Section 32 does not require an unlimited disclosure of what may well be private information. Yes.
So okay.
Yes, if I can. So when private, because how far does one go? Do you simply disclose the amount and the person disclosing? So when you're dealing with that regulatory scheme now, you say to yourselves, private donors who are interested in influencing how political parties run for election must disclose readily. That information must readily be in the public domain. So that information is not just the amount, the donation that is there. It is who has donated that amount and why they have donated that amount. What interest do they have in donating that amount? Let's be fair. The interests of the private interests in our political system may well be as much as our own interests as the public. When they sponsor political parties, they are genuinely interested in sponsoring political parties that are ethical, that are able to govern in accordance with the Constitution. That must be something that that should be appreciated. That should be one of the reasons why it should be appreciated. Those elements, private donors, whose interests are to corrupt the electoral system or to undermine the democratic system by sponsoring political parties on the basis that they are going to gain in future, would obviously suffer. That motive would obviously suffer considerable resistance if there is the disclosure requirement that is contended for. But we're dealing with constitutional rights, and one has to be able to say this particular. If, for example, if the American government, were to sponsor the and I choose any party with no association to the party, the DA, were to sponsor the Democratic Alliance, it would be of interest not just to the ordinary citizens of the country, to everybody who, even the Americans themselves, must be interested in why is America interested in sponsoring the Democratic Alliance in South Africa. So I'm saying the disclosure regime that one requires in my submission would not sit comfortably within the Access to Information Act that is envisaged under Section 32A. That is why Parliament is saying our responsibility to regulate political funding comes from Section 236.
I'm not too sure it does, because as you correctly indicated, that talks about public funding, where there is equitable distribution of funds and so on and so on. So Section 236 seems to be very specific on public
No,
funding.
and I accept that, Chief Justice.
Yes, yes.
But the proposition I make is that the principle, if Parliament were to say, do we have a constitutional obligation to regulate funding of political parties? They will start off in Section 3326 and say, well, we can actually regulate funding in as far as Section 236 is concerned. But what other source of constitutional authority do we have to regulate funding?
Just there, I think that the challenge, you may be right, but I think the challenge might be this. 236 exists in recognition of the poverty levels in South Africa and our background. That unlike old democracies, you don't have everybody, as a generalization, being so financially well-resourced that they can participate meaningfully in the democratic process as a party, unless the state assumes the responsibility to contribute something to them. Therefore, the practical reality is there must be a budget that would be given to the IEC or whoever to distribute to different political parties according to their strength, determined by how many votes or how many members of parliament they previously had. So that seems to be tied up to the funds that actually come from the state. I don't know, it could be some guide, but I'm not too sure that it can form the basis for what is being contended for.
Sorry, Chief Justice, to interrupt you. But all I'm trying to submit, Chief Justice, is that if one were to scan through the Constitution to look for a phrase, party funding, that stands out, it would be 236. Of course, the 236 then is limited to exactly what you Chief Justice, you have said. But what we say, in as far as this system of regulating private funding is concerned, it's not just the access component of the regulation that the applicants are seeking to have. It is the recordal aspect. So one must find that in Section 32, Pyre should have had a recordal requirement. And so political parties as a specific group should in fact be recording funding. And I accept completely that one cannot expect a situation where money is just put in bags and given and they're not recordal. That the system of accountability and to avoid the corruption of our electoral system, that there is a requirement to not just record. You may well expand it further and put further strict regulatory processes that are contained in, for example, the United States regulation of political contributions. But we say it's not an access to information problem, because that regulatory regime is intended to isolate a specific party, a specific anyone under the Section 32. And so what we're doing is we're seeking to isolate political parties. And we're saying political parties ought to be regulated differently because of the specific role that political parties play in entrenching our democratic system. So we would say, when my learned friend was debating with the bench on a difficult question asked by Justice Kachalia, which was that what the applicants are saying is we've come here simply for regulation of registered political parties. So I'm not sure whether it was just Kachalia or just Jafta who then said, but what about the variety of other entities that play a critical role in supporting political parties? For example, the example of the SACP. They are not registered, but they support the ANC. So whatever you're trying to avoid in the corruption, if you're trying to avoid the corruption of the political system or by private funding, you don't avoid it by simply regulating registered political parties. The legislature may well say, we're going to go beyond just registered political parties to ensure that we target even those engines that are used by registered political parties in order to generate private funds. Because the money gets into an entity like Sanko or Kasatu from a private donor. Because this law that they are proposing is a law that doesn't cover registered political parties, it may well be that they adopt a different attitude. They are not subject to the regulation that the registered political parties have. But what does it do in as far as the primary objectives for that disclosure requirement is concerned? It does not help 2 points which are very important raised by the applicants. Firstly, regulate the use of private funding in order to corrupt the integrity of our political processes. Secondly, it does not necessarily play a role in informing people, because COSATU doesn't have or SABC doesn't have in terms of the legislation, or in terms of the proposal, or the constitutional point taken by the applicants, they are not bound by what this new legislation or this amended legislation would have. They're not bound by that. They don't have to do it. But the legislature may well say, we're not only going for registered political parties, we're going for political role players. We're going even for churches. We're going for I mean, it's far-reaching. They may even say individuals who are participating as independent candidates must also have a disclosure regime, an automatic disclosure regime, because we need to know why a political individual has risen to high heights.
That's what they are saying.
Yes,
they are covering independent candidates as well.
But they are saying that amend Pyre or declare Pyre as unconstitutional in order to provide Parliament with an opportunity to amend, so that that is provided for.
So you are saying we must not confirm the order of the High Court?
Yes.
And leave it there and allow Parliament to proceed with what it is doing now?
Absolutely. We even
what is the fear, what is the concern, what is the possible harm if confirmation were to happen?
So then Parliament must look at all the judgments that have been written on this subject. The minority, the majority, the High Court, and this constitution, the judgment of this court, and say to themselves, are we meeting our constitutional obligations by pursuing a regime of regulating private funding of political parties in the manner in which we are doing? Should we abandon that and just amend Pyre? Because it's Pyre that is now a target. Pyre is now a target. The constitutional invalidity order would introduce uncertainty as to how Pyre should be used as a vehicle for achieving the very transparency that it's intended to achieve.
You see, as I understand, and I'm thinking aloud, I still have to think deeper. As I understand the applicant's case, they are saying Pyre does not give us what we are promised by Section 32 of the Constitution. And we want this court to pronounce itself on that matter, so that, I'm extending it now, there's an appreciation by Parliament that it needs to address this issue as a matter of obligation. Now, if you don't confirm that, Parliament is free to dump that bill. What obligation is there now for it to come up with that legislation? When their proposal some many years back for them to come up with legislation on private funding, and former President Kgalema Motlanthe produced a powerful motivation to that end, nothing happened. Why can't they drop this bill? Whoever sponsored it, just drop it, and it doesn't become an act. When that happens, then there is no articulated obligation, no articulated constitutional obligation on Parliament to pass legislation that regulates private funding. They can sit back, just as they have sat back for how many years now? 24 years since we became a constitutional democracy. Can sit back for another 24 years, no obligation. Yes, there is a need, and we must attend to it. Yes, we will, yes, yes, but nothing happens. The difference that the applicants seek to make is that you people had more than 2 decades to do this thing. You did not do it. We need the intervention of the court to speak authoritatively on the obligation that rests on your shoulders in this regard, especially because of the allegedly high levels of corruption in our country.
Chief Justice, I mean, this court has spoken quite clearly on its powers and how far it can go in telling Parliament where and how to perform a constitutional responsibility. It's very important to extend a presumption of constitutional behavior on the part of the legislature, and not assume that the process of legislating that is been embarked now is simply another process that will be dumped later on. It will be quite, with respect, it will be quite extraordinary for the Constitutional Court to say, no, but I mean, you know, we want to make it clear that you've got this obligation because you've been remiss for 24 years.
I'm sorry, forgive me for No. That was just by way of elucidation, just to say something needs to be said. The principle needs to be articulated. They may well pass legislation, they may not pass legislation, as long as we're not hearing anything that says they consider themselves to be under any constitutional obligation to do what they are doing.
No, but they accept with respect that they have a constitutional obligation to do so.
Flowing from which section?
They say it's flowing from Section 19 to regulate political activities. Section 236, I have debated 236 with the Chief Justice, and I take no further than even Section 7.2 would be a basis on which Parliament says this type of information and this type of political party or this type of person who performs a critical role in our democratic system ought to be subject to a particular regulatory. Because, Chief Justice, Chief Justice and judges, it must be accepted that the Constitution already imposes a duty on Parliament to regulate funding in order to enhance multi-party democracy. And I accept the limitation there in 236. But I say that principle of that obligation to regulate funding, the Constitution doesn't spell it out, doesn't say public funding, private funding. So it's open to Parliament to say, well, you know, for the role that private funding plays in our democratic system, we need a specific legislation to do so. They are doing that already. Their main problem, and this is a problem that that obligation must come at the back of a constitutional invalidity of a legislation that they consider to be constitutional.
Mr. Masuku, Section 236 doesn't regulate funding. It facilitates the provision of funding. It reads, funding for political parties. To enhance multi-party democracy, national legislation must provide for the funding of political parties participating in national and provincial legislatures on an equitable and proportional basis. Meaning, you may be registered, but if you are not participating already in the structure, this does not speak to you. It is the allocation to those who are participating already. If you have never participated before, this doesn't apply to you. So it's all about providing funding.
I have accepted that.
I'm saying it's not about regulating funding. No. It's about facilitating the provision of funding by the state.
No, with respect.
Which part says yes?
to enhance, in other words, what is the purpose of this funding of political parties? It is to enhance multi-party democracy. So the legislation that is being envisaged must enhance multi-party democracy. But the context of enhancing that is, as you put it correctly, confined to political parties that are in the legislature. So I'm saying when political parties are looking for an obligation to regulate or to pass legislation that deals with funding of political parties, part of its purpose would be to enhance multi-party democracy. It's not necessarily when you as I pointed out earlier on, private funding plays an incredibly important role in the democratic system. So in the enhancement of this multi-party democracy, private funding may well play an important role. So I'm saying when we try to source the authority of Parliament to pass legislation, I've come up with Section 7.2, I've come up with Section 19, and I've come up with the Section 236. I can't do better than that now. I think.
I was just saying there's nothing about regulation there.
No,
It's about facilitation
with respect,
from the state.
with respect, what it says is national legislation, the vehicle through which Parliament will enhance multi-party democracy is a legislation that must provide for the funding of political parties that are in the national legislature. So when Parliament says we're going to pass legislation that deals with funding of political parties, I'm pleading to the court that they see that the court looks carefully at that provision and asks itself, should we then say Parliament does not have a source of authority for the legislation to regulate political funding? We say Section 32 is not the source of that authority. We may be wrong, and the court will tell us whether we're wrong on that. But we have given...
Sorry, but why shouldn't 32 and 19 be read together? They're not, your opponents don't source the authority in 19. They say that to give you, that these rights are interdependent. So they source it in both 19 and 32.
Yeah, so the approach that they take may well apply to the right to housing. So you may read the right to housing, Section 26, together with the right to access information. You may read the right to dignity with the right to access information. It's the approach adopted with respect, Justice Kachalia, must be to give content to each right. Firstly, give content, before you do with the intersection and you read one right with the other, give content to the one right and the other right, and then see where they intersect, and see whether the right one contends for can only exist via that intersection. As I say, I mean, previously we were bold enough to say, actually, you don't need the access to information. You don't need private funding information to cast your vote. I'm not there anymore. I mean, I'm persuaded that funding information is important. But I say every other information is important. Why isolate this particular funding for constitutional recognition? Why? Because voters, it's a very interesting proposition. This concept of an informed vote, it bothers me incredibly. It bothers me a lot, because a professor of political science who is interested in how political parties function will be interested in everything about the political party, its funding, trends, the policy developments of that party, and they will have detailed, when they walk into that booth to cast their vote, they are informed by all that knowledge. But someone from the rural areas, my grandmother in the rural areas, is hardly interested in political funding. She will be interested in the colors of the party of Mandela, or if she has changed her mind in a red color. I won't mention the blue color. Where I come from, it would not pass. But
I'm sorry, Mr. Masugu. I may have incorrectly heard you. Did you say we're looking for the source of the power? Or are we here concerned with the source of the obligation? I assume that Parliament has a general power to legislate on any subject matter. But the issue here is whether Parliament had an obligation to pass legislation that meets certain standards. And if it hasn't, then the applicant is saying you must order Parliament to do so.
No, I think that clarifies my difficulty with trying to find a specific provision, and I'm grateful for that. I think that's the submission that we...
Your bottom line is you don't want us to conclude that there is an obligation that flows in 32 in circumstances where you believe that Section 32 does not provide for that obligation to legislate in the manner proposed by the applicant. So you're just seeking to help us arrive at the correct conclusion.
Perhaps the first declaratory order.
No, I'm just saying your point is you're seeking to help the court to arrive at the correct conclusion in relation to what Section 32 is about.
Yes, that's correct. So in relation to the declaratory order, we say, as I pointed out right at the beginning, declaratory orders in the nature that are sought in paragraph 1 of the order would be necessary where there was constitutional ambiguity, and to bring absolute light to the state of affairs, then you then must declare. But as I pointed out, isolating for special constitutional recognition private funding information may well be that it's not necessary to do that, to make a declaratory order that specifically isolates private funding as a specific source of information for the exercise that is required for the exercise of the right to vote. So I'm saying there is a whole range of information that one as a voter would be interested in, and a whole range of other information that one would. So if the declaratory order is, it is declared that information, I don't know how to put it, but just information that is important for voters to cast their vote, to assess political parties and to decide which one to join and which one not to join. It's not just funding information that is necessary for that right. So I say, if one were to make a declaratory order in the terms of paragraph A, it obviously has legal implications that are far-reaching, because obviously you've elevated private funding to a constitutional position, and it enjoys constitutional protection. Every other information that may be necessary doesn't necessarily enjoy that protection.
Isn't there all other rights, all other information that affect this right readily available? Aren't people just too keen to disclose that information with a smile? And the reason why there is special focus on private funding is that that one is not readily available. There seems to be a reluctance to dish that one out.
Perhaps the analysis should be based on a Section 36 or Section 36 analysis, where one says, you're balancing rights. A donor has got rights. So if a donor is acting in exercising a Section 19 right by donating money to a political party to help the political party champion a particular cause, they're exercising that right. It's their right to exercise. I'm saying, would it promote multi-party democracy to, as a general proposition, to take away the right of a donor to say, you know what, I'm going to sponsor all of them. I'm going to sponsor all the political parties that are running the show. But I don't want to be known. I just want political parties to be able to reach wherever they want to reach. I don't want to be known because my primary job is not in politics. I just want to promote this, but I don't want to be known. This disclosure requirement would take away that ability.
So there is some reluctance, some
No, with
low-lying
respect-
reluctance.
With respect, it's not correct that there's reluctance. Parliament is already engaged with that process. It's not correct that there's reluctance.
But I'm just trying to understand the statement you've just made about the rights of the private funders. I'm not too
Can I
sure.
clarify, Chief Justice?
Please.
In analyzing the one right that we're concerned with, which is the right of a requester to have access to private funding information, we are saying that that right ought to extend to information of a private nature coming from a private donor. So the subject, the target of the exercise of the right is a private donor. We cannot do so without looking necessarily at the donor's rights themselves. That's how the balancing of rights is very important. And that's what Pyre does, actually. Pyre tries to balance different rights, and that's why it's got mandatory disclosures and other non-mandatory disclosures. Because you've got to ask the question, what right does a donor have to ask that their name be not associated with the political party that they've sponsored? And I can understand there will be those private donations that are suspect, whose intentions are not noble, whose intentions are not constitutional. But there are, those contributions by funders who say, no, we're quite interested in just sponsoring political parties, but we don't want we don't want the political atmosphere to now focus on us.
Well, then everybody can just come and say, we are private funders, we don't want to be known. What then happens? We just want to help a multi-party democracy here. We are not here for recognition. We are not interested in politics. We just want to give out money. But please make sure that people don't get to know that we are funding this or all political parties. How then would we
I just
go?
cry out for balance. So that's an extreme situation where private donors abuse their rights in order to, for purposes that may well be unconstitutional. And what I'm saying is that in assessing the contesting rights, because it's not just one right that is involved, there are competing rights that are involved. And I'm saying place in the scales of your analysis the rights of people that are also involved and those rights are rights of people who are making the donations themselves. And I mean, it comes to the question that Justice Froneman asked earlier on, whether or not a over-regulation of private funding may in fact stifle the participation of private interests in the political, in shaping the political space. And it's that balance that ought to be struck. So in circumstances where democracy and the rights themselves will be affected because now people don't have money, or political parties don't have money to campaign or to run their causes because private funders are saying, no, we can't do this because if we do it, then it's going to be focused on us. It's us, not you.
If we are to confirm the order, what are we to say about the bill? How are we to deal with the reality that there is already a bill in place?
Oh, Chief Justice, that's hard. Because essentially the impact of a confirmation is to stall the process that's going on in Parliament and get parliamentarians to start running around trying to figure out how to comply with this order. And of course, it may change completely, that they may take the current legislation and simply put it under Pyre and regulate it under Pyre. So there will be a section under Pyre that deals with regulation of political parties funding. and then disclosure requirements, recorder requirements under Pyre. So there would be a substantial amendment of Pyre. That may well be the route that Parliament would take. But yes, I mean,
Or we may make it clear that we don't seek to stall that process or to dictate to them as to what to do or what not to do.
but against an order.
It may become clear in the reasoning and the order we ultimately make, because it's open to us to vary the order even. We may well get to the point where we are able to allow that process to run its course and say whatever needs to be said about Pyre and whether changes need to be effected there, or even provide options.
Yes, we have, the Parliament and the government would be anxious with the confirmation of this order. So it's really, it's now in your hands to deal with that. But could I then just respond to some of my learned friends' arguments, which were made against the minister?
Just before you do that, Mr. Masuku, may I give you this simple one, which will surely accompany you to the airport. This draft bill that is intended to address these difficulties, would you have any knowledge how far away in the pipeline is this draft bill at all? This is a simple one intended to accompany you to the airport.
My Lord, I'll be speaking in generalities. I have no idea, but I know that there's been an invitation to the public to comment on the bill. It's in a bill form, basically. It's in the form of a bill. But other than that, I have no idea. But I'm assured by the minister, and it makes no difference, and I can't carry that assurance to the court, but the deputy minister who has taken instructions from assures me that the Parliament is keen to get that passed. They are driving the process to get that bill passed. Even though my learned friend doesn't particularly enjoy ministerial assurances, from his laughter, it's clear he doesn't. But I proceed from a presumption of integrity that Parliament, or when a minister says we are keen to get this done, then they're keen to do it.
Except that is only one of the many members of Parliament, the minister and the deputy minister.
Yes, but they champion, they are the ones helping Parliament to think through the issues.
But they don't decide. But they don't decide.
Yes, Parliament will ultimately decide. In the majority judgment, there were a number of remarks which are very important for how this court should look at the current challenge. One, the court criticized the applicant and said that they had not frontally challenged Pyre. They had not said exactly what was wrong with Pyre. And the court had said, when in disagreeing with the majority judgment, it said, we disagree with the majority judgment that Parliament has failed to fulfill its obligations to enact legislation envisaged in Section 32. And then it says, the minority judgment seeks to have Parliament legislate in a manner preferred by the applicant, which would be in violation of the doctrine of separation of powers. With respect, one must carefully look at what the majority judgment said about the application at that time, and look at this application and determine whether or not this is a frontal challenge to the constitutional validity of Pyre. What you will not find in the application is a direct challenge to the constitutionality of things that they criticize, but they don't get to a point where they say, declare the definition of private bodies unconstitutional, or declare this particular section of Pyre to be unconstitutional. All they want is a declaration of Pyre based on the fact that they are not able to access information. But that in itself is not entirely correct. What is correct is that when the applicant
I'm sorry
sought-
to interrupt. In the founding affidavit, in paragraph 68, 7 grounds are set out on which the applicants allege Pyre is deficient. Then they go on in 69 and 70 and 71, dealing with the deficiency between natural persons and that political parties fall in between the cracks. And the only response to that was that these are noted. They are not disputed. So the applicant sets out its case, as I understood it, and said, Pyre is deficient because of reasons 1 to 7, and then in 69 and 71 they go further with a further one. And then the response comes and it says, these are noted. There's no saying, we deny them, they're wrong, or anything of the sort. So that's what I don't quite understand when you say there hasn't been a frontal assault on Pyre.
No, sorry, just for a moment, when you gave me the references, I wasn't able to reach them before you finished making the references. But thank you.
Paragraph 68 on page 38.
Yes.
69 and 70 and 71, and then your response is on page 129, volume 2.
This is my response to Justice Froneman. I take your criticism. They do say why they think Pyre is unconstitutional, but I focus on the order that the court is being asked to confirm. The order specifically identifies as a constitutional deficiency of Pyre, being just the non-recordal and the disclosure of information on a continuous and regular basis. And I'm saying that the submission I make would be that doesn't rise to a specific challenge to a provision in Pyre that they say is deficient in the manner that they allege and was accepted by the order itself.
Yes, but the attack, as I understand it, is on the deficiencies in the form of omissions. So if the allegation is Pyre doesn't make provision for X, Y, and Z, so it's an omission that is challenged. I'm only asking you, you said Pyre, as I understood your argument, and I may have misunderstood it, you say there wasn't really any facial challenge of Pyre.
Yes.
And
I did say that.
If that is so, then I'm not quite sure what this case is about.
I don't think it would rise to that level of uncertainty, but what I say is that if one looks at the order that was being asked to confirm, the order doesn't reflect what they complain about in the affidavit. So when you are setting aside the Pyre...
I'm sorry, once again, will it cure your difficulty if in our order if we go that way? I'm not saying that any decision has been made, but if we do consider that there are deficiencies, will it cure your difficulty if those are spelt out in the order?
I would be wrong to try and prescribe how that would happen. I see my role as simply to make submissions in respect of the order that you're being asked to confirm. In the course of writing the judgment, if you should say, for example, that the definition is unconstitutional, then so be it. I can't fault that. In fact, that's what happened in the minority judgment.
I'm debating it with you on the basis that you say the order is deficient. And I'm asking you a question. Do you consider that it will be legally sufficient if the order is taken further and, sets out any deficiencies, if there are, and I'm not expressing any view on it, will the order that you complain about satisfy you if it sets out what the deficiencies, if any, in Pyre is or are?
I couldn't say yes without considering the case, so my answer would be no. It wouldn't be. I would rather be understood to have stood my ground on the one point.
I'm not forcing you to answer no. If you say no, that's fine.
No, I thought I would motivate a bit more of why I say no. Oh, so just pointing out one deficiency which was raised, the deficiency relating to the definition of private and public bodies. Even if it was made clear that political parties were covered under the PI, it wouldn't satisfy the applicants, because what they're asking for is an unrestrained access to private funding information that must be disclosed to the world, for the world to see, not for the exercise of a particular right by a requester, but for the world to see. So we say even if one were to cure the deficiency of the definition, that wouldn't help the case of the applicants, because their complaint is broader than that.
How do comparable democracies deal with this kind of information? Is it somewhat protected, or is it readily available? Can it be accessed by people within and even outside of the country? How is it managed?
The best, I can't give you, Chief Justice, the only reference I can come up with is a reference in the United States, where there is a specific legislation that deals with private funding. It's not under general disclosure legislation. And in fact, in the DASA case, that was exactly the same proposition that the honorable judge in that case said. He said he has explored a number of jurisdictions and couldn't find a jurisdiction where there was a regulation of political funding under general disclosure, under general access to information legislation. But the US has got an act that specifically deals with political funding.
No. I was only focusing on the accessibility of that information. Is it accessible to the whole world? Is it accessible to only those who need it and need to motivate quite significantly for it? Is it handled as confidential information or information that is available for public consumption?
No, Chief Justice, I can't refer you to a comparable jurisdiction. So the court would submit, should not confirm this, both declaratory orders. We would, and this I give as a concession, we would have no difficulty with a declaratory order that private funding information is important for democracy in the light of the first declaratory order. But we wouldn't say so based on the application of Section 32. So if one were to say, in the exercise of the Section 19 rights, it's Section 19 rights, private funding information is important. We say it's not necessary.
I'm sorry to interrupt you. Just while you are there, is it only important, or is there an obligation to pass legislation that regulates it, or make provision that regulates it? Because it's one thing for something to be important, it's another to regulate or to have provision made for it.
So the declaratory order would be confirmed by this court if that were to go that way, is an order that private funding of political parties and independent ward candidates registered for elections for any legislative body under the Constitution is reasonably required for effective exercise of the right to vote in such elections and to make choices in terms of Section 19. The complaint is Section 32 is not, it's not implicated in that particular declaratory order. But as I say, we wouldn't have, we accept that there is the funding, private funding information is important. And I do understand your Chief Justice when you say it, I've got to take it more further than just being important. There's a constitutional duty on Parliament to ensure that political funding is not used in order to undermine the democracy of South Africa. So if that is the pitch that is made for the for confirming this particular order, then that is the order that should be confirmed. I have no.
Just to correct, almost all the time, or all the time when I say something in a hearing, it's just a proposition. I'm just testing something. It's not a firm view. Really?
No, I take no, I absolutely understand.
Okay.
My job here is to take as much blows as they can. I'll be okay, and the
just like your learned friend. Just like your learned friend took blows.
Yes. So no, I don't at all take anything out of, you've been more than gracious to me in the way you've interacted with my submissions. We would submit with respect that the confirmation should be refused, and that.
Oh, that applies to the application for leave to appeal, isn't it?
Yes.
That relates to that, but the exclusion of continuous
yes, that
and systematic.
Yes, and that amendment that they seek would be, we would say that it should not be granted as well.
Sorry, Mr. Masuku, and you've thrown me a bit. There was a debate between you and the Chief Justice in relation to whether there's a constitutional obligation or whether it's merely important. We want to understand, as far as Declaration 1 is concerned, it is declared that information, etc., is reasonably required. Does the government accept that that declaration is good or bad as a matter of constitutional obligation?
I think I have made submissions in respect of that, but the first problem.
I'm sorry to disturb you, but I just want to understand. If you're saying it mustn't be, it's not a constitutional obligation, then I understand it. If the government says it is a constitutional obligation, then we know how to approach this judgment. If you say it's merely important, but it's not a constitutional obligation, then we also know how to deal with it. But I'm not sure what point you're making.
Yeah, the point I'm making is the following. Private funding information is a specific type of information that a voter would need. It's just one type of information. Voters need more than private funding information in order to cast their rights to vote. I made that point earlier. So it's not just private funding information. The difficulty that I was pointing out to the court is the difficulty of elevating private funding information to a declaratory order. I said if there is constitutional ambiguity about whether or not private funding information is reasonably required in order to exercise the right to vote, then the court must give that declaration. But I did not shy away from dealing with the question of whether or not that order of invalidity, that declaration of rights is important. I just said, well, if it's if there's constitutional clarity that is required, and because there's some ambiguity around whether or not private funding information is necessary, reasonably necessary for the exercise of the right to vote, then make that declaratory order. We don't think it's necessary because we see it as part and parcel of a whole host of other information that voters must have regards to or could have regards to in order to exercise their right to vote. The isolation of this special type of information may well be that it's a species of a special type, and view it as a necessary right to vote. And the example, the reason why I'm not leaping for joy in giving you an open concession on the point is because we have had elections where that right did not, where that declaration was not there. And those elections could never be said to have been suffered any deficiencies because there was no regime of disclosure that the position was not as clarified in this particular situation. So I simply, as I say, it is okay if the Constitutional Court were to confirm the order, but I've made submissions as to why what other points the Constitutional Court must consider in engaging with that particular point. So I would ask that the orders are I would leave it to the court as far as order 1 is concerned. Would ask for order number 2 not to be confirmed. My learned friend asks for costs. I don't know whether I should do that because BioWatch is going to be thrown on my path. So I will desist from speaking about costs and just leave it to the court to decide whether the cost should follow the cause in our case.
Thank you, Mr.
Thank you, Chief Justice.
Nasuku.
The Justice.
Mr. du Plessis.
Thank you, Chief Justice. I will attempt to keep to what I'd promised in chambers by way of reply time, and do so by a thematic reply. The first point made by our learned friends is that Parliament is dealing with this issue, and I understood our learned friend to say that this court should be careful of the effect of its order on Parliament's processes. One knows immediately, of course, that Parliament has been dealing with this since 1997, and there is no evidence before this court at all about how far this process is, whether the minister is keen or not. I take it that the minister may well be keen. I accept my learned friend's suggestion to that effect, but it doesn't matter because there are so many different permutations as to whether this bill will in fact see the light of day. And so there is, as the Chief Justice correctly said, there is a necessity with respect for there to be an articulated obligation. The Chief Justice asked, how does one deal with a bill? At the level of this court's jurisprudence, we would offer as what we hope is hopeful assistance the decision of this court in Mazabuko versus Sisulu. It's a decision of 2013, volume 6, SA 249, the Constitutional Court. This court may recall this is the case of a vote of no confidence that had been brought in respect to Mr. Zuma, and at the same time there was a gap in the rules of assembly for the Parliament as to how such a motion of no confidence could be brought. The evidence before the court was that Parliament, through its own Rules Committee, was dealing with this at the same time as it was being dealt with by the court. And the Speaker, in fact, at paragraph 67, urged this court to dismiss the application on the basis that if there was an order made by the court, as the applicant had asked, that would interfere with what was happening by Parliament at the time.
Was that issue decided?
Yes, so it was decided, and the court said in the majority decision that for 3 reasons, effectively, the court should nevertheless decide the constitutional question. It said, first of all, it's clear that there's a lack of consensus between the parties as to what this particular rule means, and with the greatest respect, in light of the arguments from our learned friends today, there remains a very clear lack of consensus as between the applicant and the minister, at least as to the source of where this obligation arises, whether it's section 19, as the minister contends, or whether it's section 32. So there's certainly a difference of opinion in that respect. The second reason this court relied upon was its own duty, obviously under section 172(1)(a). When confronted with a question of constitutional invalidity, the court's duty is to declare that where it sees it. And for the reasons we've given, we say that Pyre must be declared unconstitutional. And the third reason the court gave was that it did not see that its declaration of invalidity would, it said this at paragraph 71, interfere or trench upon the separation of powers doctrine. The court would rather, said this court, be properly requiring the Assembly to remedy the defect that threatens the rights of the members of the Assembly, and in that process would be providing guidance to the Assembly if the judgment came out before the Assembly had finalized its rules. So we, with respect, invoke the Mazabuko decision in that respect. The second point our learned friend made was a concession, but I admit to not fully understanding whether he'd made the concession fully or firmly or finally. What was ultimately clear, though, is that in principle it seems that our learned friend does not have a difficulty on behalf of the Minister in accepting that citizens should have access to this type of information about private funding. He has effectively, therefore, conceded, at the very least, prayer one of our order. And in that context, we say that we have been substantially successful, whatever else the court may decide. He thus has effectively made the point that, in principle, we are not at odds. His difficulty, it appears, is that he seems still to think that Pyre provides access sufficiently to this information. And he has, in various guises, attempted to justify Pyre's limitations. He said that Pyre provides access to information and that it complies with the requirement of Section 32, but with the greatest respect, it does not. We have made that point factually because we, as the applicant, have applied for this very information from the political parties registered in the National Assembly, and they have denied it to us. So,
is that not a question of application versus what actually has been provided?
Well, first,
it may well be provided for, but misapplied by those that you are approaching for the information. They may misunderstand it and think that it doesn't allow them, it doesn't allow you access.
Yes. What it does is it certainly confirms that the very grounds which they've relied on, Chief Justice, to refuse the access are the complaints that we've levelled in our finding affidavit about Pyre.
I was only saying a person may rely on grounds in circumstances where those grounds do not allow him or her or it to do what they are saying. So it's got to, as you said, it's got to be approached objectively.
Absolutely.
Does Pyre provide for this which you're complaining about or not,
Absolutely.
Regardless of what the functionaries might or might not do?
Absolutely. So we're in full agreement with you, Chief Justice. We're highlighting that the objective nature of the blockages under Pyre are, as it helpfully turns out in this case, confirmed by the fact that the political parties refused that access. That's all we make by way of that point. It is important because our learned friend says, well, juristic persons would be able to gain access to this information, and political parties under Pyre could be juristic persons. Well, that's true, they could be, but of course they're not. The Electoral Act does not require political parties to be registered as juristic persons. And Section 19, which allows the rights.
But if your constitution as a political party says you have the right to sue, don't you become a juristic person? Is it the Electoral Act that defines or helps determine what is a juristic person, or is it a legal point, really? You've got a constitution.
Well,
it gives you certain functions, certain powers, and therefore you are a juristic person.
But, Chief Justice, you and I would immediately be, as lawyers, having that debate. Does it cover, is it met by the definition, is a juristic person in terms of that? And that is the very difficulty, which, as the minority said in this court, in my vote counts, it's not clear whether you're a juristic person for the purposes of the Act or not. And certainly there are political parties that do not have that type of assemblage, don't have those powers, and then they would fall out. And it's again the objective question. Objectively, does Pyre meet the requirements of access to information? And we say it certainly does not. The next point by our learned friend, again by way of topic, was that there had been elections previously and that there's then no need to have this order whatsoever. And in fact, if I understood our learned friend correctly, there was a suggestion that there might be a danger if this court went so far as to say that there'd been previous elections where this hadn't happened, that somehow there would be a doubt cast on the validity of those elections. Certainly that's what's suggested in their heads of arguments. But we say that's not so. We're clearly not contesting previous elections. Our relief is not retrospectively sought. And insofar as our attack is on Pyre, we are doing so as a forward-looking basis. And we've had the debate, again, Chief Justice, you weren't here, but 2 or so weeks ago when we were speaking about what happens if this court were to determine that the appointment of Mr. Nkosana and Mr. Abrams had to be declared invalid, what would happen to their decisions that they had made previously. And it was very clear, and on the basis of the Similani judgment of this court, the court said it can make orders and make it very clear that nothing it says affects the validity of anything that happened before. And clearly that's important because past failures clearly don't justify future illegalities. The court can deal with this, in other words, in its remedy. The further point by our learned friend is to say that we haven't brought a frontal...
I was dealing with a different point. Mr. Masuku was saying, look, we've had elections. And they have demonstrated that even in the absence of an obligation to record and disclose information on private funding of political parties, the system functions and functions well. People are able to exercise their rights. Whether he's right or not, that's a different point, but that's the point he was making.
The point that he was making with respect, if that is his point, is one which doesn't, again, go anywhere near the objective invalidity difficulty. The question is not whether one has any evidence of previous elections being good or bad, whether information was freely available for citizens to use or not. We have made the point that there is no debate. This court's jurisprudence has said that information is required by citizens in order to have an informed vote. And secondly, and again, our learned friend doesn't seem to quibble with us in argument and in their papers either, there can be no debate that if there is the potential for somebody to place a very significant donation in the hands of a political party secretly, that there is the potential for corruption. There's simply no debate about that, or could be no real debate about that. And in that context, we make the point that in the circumstances, it is that objective inquiry which leads to the conclusion that whatever might have happened in previous elections is simply irrelevant to the debate about whether Pyre from now onwards, given the frontal challenge that's been brought by the applicant, meets the requirements of the Constitution. And that then allows me to deal with the point by our learned friend that we haven't challenged particular provisions of Pyre. Well, with the greatest respect, not only the point that Justice Froneman raised in debate with our learned friend, but indeed in our founding affidavit at pages 38 to 50, we set out in great detail what we said were the difficulties with Pyre. And we would be only too happy, as Mr. Masuku seems to accept, if this court would recognize those difficulties in its judgment. Any judgment it writes, it could say, these are the difficulties identified. And as Justice Froneman highlighted, there was no response to them from the minister. They were simply noted as difficulties. And we commend again to the court the decision of this court in Glenister. I know that I was attempting earlier, Deputy Chief Justice, to answer a question that had been raised with me about Glenister, but it is important because I do, with respect, believe it will be of assistance to the court to see that the framing of the relief in Glenister was precisely on the same basis as in this case. In Glenister, at paragraph 248, the court found that the statute creating the DIPSI, in the same way as in this case Pyre, offends the obligation on Parliament to create an independent anti-corruption unit. And it offended on that basis because of a number of difficulties that the applicant in that case, I only happen to know this because I was in the case, had identified for purposes of that constitutional challenge. And the court's decision in the end, through the majority, was provided in its order at paragraph 251, where the court said, it is declared that Chapter 6A of the SABC Act is inconsistent with the Constitution and invalid, and exactly the wording we're seeking here, to the extent that it fails to secure an adequate degree of independence for the DIPSI. And that's the relief that we seek. We are happy to have the court in its judgment, as it did in Glenister, highlight those deficiencies, but out of a separation of powers concern, leave it to the legislature to decide how it wishes to.
Was there any suspension there?
There was. So that was the other point.
Question.
Yes.
What was being suspended
Yes.
and why?
Yes, the suspension, I suspect, was for the same reasons that I debated with you, Deputy Chief Justice, because in paragraph 6 of that order, this court said that declaration of invalidity is suspended for 18 months for Parliament to remedy the defect. And with respect, I take the Deputy Chief Justice's point, but one must understand the context of where this order is being sought. It is so that there is a timeline, so that Parliament, which has been dealing with this for nearly 2 decades, can finish this job, and it can do so under something of a discipline of this court. So we ask it for that reason and that reason only. The next...
I just say, Mr. Duplessis, there are other cases where there was no suspension.
there certainly may well have been, but we embrace this one.
I'm sure you like this one.
There is furthermore, the point by our learned friends in response to the question that Justice Jafta raised. Justice Jafta was saying, well, as he understood our argument, and with respect, Justice Jafta, you seem to have understood it in the way you captured it, you can't expect voters to request this information all the time you need a form of continuous disclosure, however that system might work. And our learned friend said, yes, but the limitation requirement here is important and justifiable, and he attempted to talk about the balancing of private rights and privacy. Well, the first point is, of course, that privacy rights are attenuated rights. We know that from this court's jurisprudence, and that the closer you get to the public realm, the more attenuated your privacy rights are. And political parties, we don't need to debate this again, are at that edge where they are par excellence within the political and public space. But most importantly, the attempt by our learned friends to engage in this debate about limitation is a debate which happens wholly outside of the evidence, with the greatest respect, because the minister didn't make any factual or legal submissions in their papers about the justification. The challenges to Pyre were set out, and as Justice Froneman noted, they were simply noted. The important point, of course, is the Constitutional Court's own authority, and we just leave you with two authorities. The Moise, it's 2001, Volume 4, SA 491, CC at paragraphs 18 to 19, and this court's decision in NICRO, 2005, Volume 3, SA 280, CC at paragraph 65 to 66, where this court stressed that it is the onus on the government party that wishes to justify who must come to court with sufficient evidence to explain why a policy or law is to remain in place. The fifth point that our learned friends raised was this debate about COSATU and the South African Communist Party, and I can be brief on this. It's true, and our case is limited in this respect to an understanding of a registered party, because that's what the Electoral Act speaks to, and that's how we framed our relief. We wanted it in relation to registered parties. But our learned friend very helpfully said that it may well be that Parliament decides to go further in its debate and it wishes to extend this to other parties as well. We would embrace that. We would welcome that, obviously, but we would stress that at this point in time, our case isn't that far. We have brought it for the reasons we have, and we focus on the registered political parties only. The final point is to answer the question which the Chief Justice said we hadn't properly answered in our debates with, I think, both the Chief Justice and Justice Jafta, about the manner in which this balancing exercise happens within the terms of Section 32, and that there's this inbuilt limitation. And with respect, the answer in some respects is given by the example that our learned friend gave, where he said, well, it depends on who needs this information to vote. And he gave the example of a professor of political science who would obviously be very interested in the information. Then he'd be able to go and exercise an informed vote. And by comparison, and I don't think he meant any disrespect to his grandmother, but Mr. Masuku's grandmother, who he said would simply not be interested in this information. Well, with the greatest respect, we must be careful not to patronize people in relation to their votes and whether they really want those votes or not. I'm sure Mr. Masuku's grandmother may have been very interested to hear that a particular party that she wants to support, by way of whichever color the party's flag waves, has been paid by a very, very substantially wealthy business or businessman to achieve a particular outcome that affects her area where she lives. She would be interested in that information. And to suggest up front that she wouldn't be interested in that information is, with respect, to draw her rights very smallly. We, in any event, say that is to ask the wrong question. It's not about whether Mr. Masuku's grandmother needs this information or whether a professor of political science needs this information. It's an objective question, whether the citizenry requires this information as a collective, the electorate. And
the Constitution says, it doesn't say the citizenry, does it?
No, but we are drawing those together, Chief Justice, through the right to vote and
you seem to be adding more to what the Constitution itself is saying. That's Mr. Masuku's problem. You see, everyone has the right. Everyone. It's not the citizenry. It's not the public. And that's the point he was making.
Yes, but the point he's making is divorced from the Section 19 rights, which he lays claim to and says that are very important as the source of where our case should be. But no, but it speaks. That's true.
You exercise your right to vote as an individual. That's why you hide yourself there.
Yes, but
so you are the one who needs the information to exercise your individual right to vote on from an informed platform.
Yes, but Chief Justice, what this court's decisions in Ramakatse and Mail and Guardian, as well as in Doctors for Life, which is a further addition to what we've not put in our heads, all make clear, is that when you think about citizens exercising their right to vote, you think about them as an electorate. They make up the electorate. As citizens, they collectively, meaningfully give effect to the Constitution scheme whereby citizens elect their representatives.
Mr. Du Plessis, is it an individual who enjoys the right to vote, or is it a group of citizens?
No, the citizen enjoys the right to vote, no doubt
An
about it.
individual one?
An individual
Exactly.
citizen.
That's where Mr. Masuku is coming from.
Yes.
To say, don't lump me up with other people, don't lump everybody together. It's an individual right.
It's an individual right, but through the lens of the Constitution's objective inquiry, Chief Justice. It's not whether you need it better than somebody that needs it in a small rural village in the Northern Cape. It's not about that. You, Chief Justice, may need much more information to have an informed vote, subjectively. But that's an irrelevant inquiry as to whether, under this scheme of the Act, together with the Constitution, citizens, as a collective, need this information. And this Court's jurisprudence is, with the greatest respect, time and again speaking about how the information required is necessary in order to see that citizens exercise this vote. And this Court in the minority judgment said that that's important because the context is one which one needs to always step back from. I don't need the vote, I don't need the citizenry alone, but that there are millions of citizens. They exercise their rights to vote in elections, and it's their propensity as a multitude that that information needs to be made available. So that's the point of an objective inquiry. Finally, we are delighted to hear that our learned friend is no longer seeking costs against us and that BioWatch has been invoked. But we do stand by our request for costs, again on the same BioWatch principle, and for the costs of 2 counsel where they were engaged. Unless there are any further questions, those are our submissions.
On a lighter note, Mr. Du Plessis, of course, a court never speaks through a minority judgment, isn't it?
It certainly doesn't speak through a minority judgment, Deputy Chief Justice.
Come across as if you really wanted to bind on this court in your heads of argument.
But we would merely say to the court this, that we would advance it as certainly a considered account of what the issues are, certainly not to be dismissed out of hand. It is persuasive at the very least.
Thank you, Mr. Du Plessis. Judgment is reserved and the court adjourns.